따모. 다 비그러봐. Good morning, everyone. We are going to start in another 5 minutes, so kindly wait for 5 minutes. Hello, everyone. Program will start in another 2 minutes. Oh, Good morning, one and all present here. Justice is best served when knowledge is continuously refined and shared. It is my singular privilege and honor to extend a warm welcome to all the distinguished dignitaries, learned judicial officers, esteemed resource persons, honor participants, and invited guests present here today for the technical session day 2. The deliberations scheduled for today focus on some of the most important aspects of criminal jurisprudence, namely arrest and bail and preventive detention laws, which are indispensable to the protection of constitutional liberties and the administration of criminal justice. Without further ado, let us commence today's academic proceedings. We now commence Module 3 on the topic arrest and bail, focusing on statutory procedures, constitutional mandates, guidelines, safeguarding personal liberty. This session seeks to examine the delicate balance between effective criminal investigation and the Constitution guarantee of personal liberty. It is now my proud privilege to introduce our distinguished expert and resource person for today's program, respected Sir Sri E.V. Chandrasekaran Chandru. Sir is the Special Public Prosecutor for the National Investigation Agency. Before the Madras High Court, he is widely recognized for his extensive experience in prosecuting complex criminal matters involving national security and serious offenses. His distinguished professional journey, profound legal scholarship, and practical expertise have earned him immense respect within the legal fraternity. So, ladies and gentlemen, may I request respected Sir to join me in extending a warm round of applause as we welcome Sir E.V. Chandrasekaran on the stage. May I respectfully invite you to, Sir, deliver your address. Thank you, sir.
Good morning, everybody. Good morning, everybody. Thank you. With the blessings of my parents and my senior, Mrs. Vrinda Mohan, an advocate of Pondicherry, I am in front of you. It is my immense pleasure that I am in Manipur for the two reasons. One is the Honorable Chief Justice, a person who is very close to my heart as a mentor, is in our state, and the learned brother AG has meticulously arranged, and he was persistent to see to that good resource persons are available here. And after my session, you will be having Senior Advocate Sonia's session, and followed by that, a session by eminent High Court Judge, Honorable Justice Nirmal Kumar, a colossal on criminal law. Okay, I was given a questionnaire by AG's office, so the questionnaires are also in the background of my mind in the whole session. The topic of the day is arrest and bail. What are the components of the session? One is the procedural aspects, then constitutional mandate and the guidelines. As you all know, ladies and gentlemen, that this is a country governed by the rule of law. What is rule of law? You can give some mics there. Can give, where are the prosecutors? Where are my brother prosecutors? Prosecutors are not present? Any prosecutors here? Yes. Police people who are on the back side? Yes. Military people? Yes. Then advocates are also there? No advocates? No, I should understand what is the composition of the gathering. Public prosecutors, police, Then where are revenue people? Is there any revenue people here? People from revenue? No? From administration? But for police, civil administration? Okay. What do you mean by rule of law? Anybody? Prosecutors? I am not your teacher. I am not going to give you any marks. Okay, after an hour I will fly down to Madras. So you can answer anything. Give the mic to PP. What do you mean by rule of law? Nobody wants to answer. The program should be not monologue, it should be dialogue. Yes, I understand people in Manipur are very peaceful, they don't, in any Viratham, Mauna Viratham. You know what is Mauna Virath? Maun Virath. Not talking.
So I'll just give an answer according to my knowledge.
You please sit, madam, and please sit and answer. Yes.
So rule of law is that everyone is subject to the law.
Excellent.
And then including individuals, then business, administration.
Correct. Thank you, madam. See, rule of law basically means law is not above law. Point one. Law is not above law. That is, every law or any law in this country should subjugate itself to the constitutional law. Point one. Every law in this country is subservient to the constitution of the country, or else by process of judicial review under Article 13 of the Constitution, it will be struck down as ultra vires the Constitution. First thing is, law is not above law. Then, lawmakers are not above law. No doubt Parliament make laws, but that doesn't mean that they are above law. So, law is not above law, lawmakers are not above law. Third is, citizens like us are also not above law. If all these three components have a very smooth say in this country, then we can safely presume that there is a rule of law. If there is any aberration in this, then it is very difficult to presume that there is rule of law in this country. Okay? I can say with all pride that this is a nation after 1947 has not seen any revolution. What is the reason? Courts are there, police is there, our brothers from military, they are governing the country, protecting the country. Look at Pakistan, it has almost got torn into pieces. Look at Bangladesh, look at Sri Lanka, look at Nepal. This is the only country, with all pride we can say, that there is rule of law, because people still believe that there are courts which deliver justice, there is police to maintain internal security, there is military to manage any external threat. So every person in this country, the enforcement or the need for enforcement of fundamental right, every one of us should always think there is a concept called as fundamental duty in the Constitution, and in which I want your kind attention to 51 capital A small e. What is 51 capital A small e? Common brotherhood. See, which is also reflected in Article 17. There shall be no untouchability on any grounds in this country, and every one of us should endeavor to have a common brotherhood. What is common brotherhood? We shall not discriminate anybody on the grounds of religion, race, caste, place of birth. This is one important aspect through which fraternity in this country can be achieved. If there is fraternity, then there will be peace in this country. You believe in this, my dear? Say yes or no. Yes? Yes, thank you. At least I can hear one yes. I have never seen such a silent audience in my whole life. For 30 years I am addressing. What is the secret in this silence? I love you all so much. God should give me a gathering like this throughout my life. Not even a single response. So silent you are. Yes. Then 31 capital A, J, small j. What is it? Endeavor should be made by every citizen of this country to rise up such that the nation will also rise up. So every citizen in this country should fight for fraternity and barring all the small limitations in us, and we should always strive to go up. See, I am invited from Madras. What is the purpose? AG thought Chandru has got something to disseminate to the people of Manipur. So every one of us should carry some torch. This is a national service. Okay? Yes. Now we'll come to the real topic of the day. That is arrest and bail, statutory procedures, constitutional mandate and guidelines. Before that, digressing for a moment, there is one important article in the Constitution of India, which is Article 141. 141 says laws declared by the Supreme Court are binding across the country. Laws declared by the Supreme Court are binding across the country. Article 245 says Parliament make laws for the entire country or for the state or for any part of the state. What is the difference? Article 141 says laws declared by the Supreme Court. So Supreme Court basically doesn't make laws. Parliament, what does it do? Make laws. See, the distinction is Supreme Court declares laws, Parliament makes laws under Article 245. But what any judgment, if the Supreme Court has laid down an authoritative precedent, that precedent is binding from Kanyakumari to Kashmir, and from this side to West Bengal or Manipur, that side to Gujarat. So this is a country governed by the doctrine of stare decisis or rule of precedence on the one side, that is whatever the Supreme Court says, that this is the law. If the Supreme Court declares that something is law, that is binding across the country. On the other side, the Parliament makes a law and it passes this test of procedure established by law, due process of law, then on the one side we are governed by statutes, on the other side we are governed by judge-made laws. Your High Court, the judgment of your High Court, you are bound by that. Right? If my High Court, Madras High Court passes a judgment, the whole Tamil Nadu is bound by that. If Supreme Court gives a judgment, both Manipur, Tamil Nadu and across the country, everyone is bound by that. So, why I am telling all this is, apart from CRPC or BNSS, apart from Constitution, Supreme Court guidelines binds the entire country, and if anyone in this country doesn't respect the dictate of the Supreme Court, it is called as, if you don't respect the Supreme Court, if you don't give effect to the Supreme Court, what happens? What proceedings? Contempt, excellent. I am hearing the second word of now. Super. And then, what is Article 19 of the Constitution, my dear? I have got some chocolates. If anybody answers, I will give chocolate. Yes. What is Article 19? Excellent. Give a clap for her. But this is not Manipuri clap. This clap will not even kill a mosquito. Right. Article 19, imagine there is no Article 19. Chandru would not have been here today. Right? If there is no Article 19, no freedom of speech, and I cannot even show signs like this, leave alone talking. Article 19, 1A, that is right to freedom of speech and expression. Similarly, very important is Article 19, 1D. What is 1D? Freedom of, from Madras to Manipur, freedom of movement. Article 19(1)G, becoming an advocate, becoming a professor, becoming a military person. 19 is very precious and close to everyone's heart. It gives the right to freedom. 19 subclass 2 imposes reasonable restriction. AG has invited me to give a speech on arrest and bail. I cannot stand here and talk something which is very derogatory to the nation, affecting the morals of the country and the security of the state. No person in this country has any right, including fundamental rights, which are absolute in nature. That is only a lazy man will always claim for right. You believe this? A person who is a patriotic person will always believe that I am here in this country to do my duty also, and rights are there, it will protect me. Codes are there to protect me, fundamental rights are there. So basically, no right in this country is absolute. Every right has a corresponding duty. Excellent. One constitutional expert is sitting somewhere, I do not know. 19(1)A is also governed by its reasonable restriction by 19 subarticle 2. Now coming to 20, article 20. What is article 20? 20 subarticle 1, ex post facto laws. That is, criminal laws should not have a retrospective effect. Right. Then what is article 20 subarticle 2? Double jeopardy. What is it? No person shall be prosecuted and punished twice for committing an offense. What is 20 subarticle 3? Very, very important. What is it? I am an old man, 54 years. 20 subarticle 3. Doctrine of self-incrimination. That is, no person shall be compelled to be a witness as against himself. What police will do the moment I am arrested? They will give me bouquets and kiss. What a policeman will do? What he will do? See, imagine a scenario. I am from Madras, right? But for in this place, I go for a imagine, okay? Don't pray that it should happen. Chandru goes for a walk in Manipur, right? With all this hairs unfurled, putting some other rough cloths, right? Police stops me. This is the whole purview of the session today. Police stops me, takes me in their jeep to an unknown place. I don't understand their language, they don't understand my language. This is another joke. Imagine Chandru do not know English. What is the language in Tamil Nadu? Tamil. What is the language in Manipur? What is the language in Manipur? Manipuri. Okay. If Chandru is waylaid by a policeman in Manipur, what will be my reasonable expectation? If somebody stops me wearing a khaki uniform, what will be a reasonable expectation of a man? SP sir, what is a reasonable expectation of a man? So, which state do you belong, sir, SP sir?
I am from Karnataka, sir.
Karnataka. So, he is also my border brother. Right? My border brother. Right? Suppose he comes to Tamil Nadu. Imagine he doesn't know one word of Tamil. Our SP is waylaid by a railway police of Tamil Nadu. What will be your first expectation, brother?
He will question me about something.
Excellent. He will just think that that man should answer. A man who is stopping, his expectation will be, why is that this man is stopping me? Right? So what that policeman should do? This policeman, because I have told you at the very outset of the class that this is a country ruled by rule of law. What is rule of law? Law is not above law. Lawmakers are not above law. People like us are not above law. So my expectation will be, why this man, 19(1)(d) says what? 19(1)(d), freedom of movement. So constitution is not like a waste paper. Constitution is a sacrosanct document. It was given by the Constitutional Assembly by our forefathers. Right? Now, as our SP rightly says, any man under any garb of police, military, NIA, CBI, any law enforcing authority has no authority to go into a poor man's hut even if there is no door. You understand, my dear? There need not be iron curtains. Every man's, in South India, I do not know about here because of the chill climate, I do not know. There are houses, my brother knows, there are houses in Tamil Nadu still. In villages, there will be only a sari in the place of door. Am I right, brother?
Yes, sir. Yes.
There will be a sari, that's all, which will do the work of a door. Anybody, any rat or cat can go inside, but not a law enforcing agency. Because Article 21 stares at everybody's face. What is Article 21? No person shall be deprived of his right to life and personal liberty except in accordance with the procedure established with law, by law. Now, you need not have an iron curtain. You need not have national security guards outside your house. Article 21 prevents everybody's house, every investigating agency, that investigating agency should not misuse law. Yesterday morning, I do not know how many of you listened very carefully to my senior Siddharth Luthra's speech. He said the duty of, I am a PP of NIA, right? He said the duty of every policeman and prosecutor is to not prosecute an accused merely because he is an accused. We should prosecute the guilty. This one word makes every change. Now I am telling the duty of every policeman in this country entering an investigation, minimum, I cannot call it as courtesy. It is the requirement of law is you explain him what is the crime that he has committed. This is the first and foremost requirement, my dear, before going into the provisions and all. Right? See, just imagine I am walking on the road, a man in a police bullet or a jeep stops me. How many butterfly flies in my stomach first? How many butterflies flies? Policeman stops you. What happens immediately? Will not there be an adrenaline rush in you? Say yes or right, yes or no. See, we are all people with sensibility and sensitivity, right? Any law enforcing agency comes and takes you off. See, this man will lose confidence that this is a country governed by constitutional law. If the policeman comes and says, explains, see Mr. Chandru, you have committed this offense at this particular place, at this time. So for investigating in that, it is a very grievous offense, which punishment is obviously more than 7 years. Only if things are stated like that, then I will say that yes, I am coming with you because you have stated the grounds of arrest. Kindly inform X or Y. Okay. I will give another one illustration about grounds of arrest. Okay. Now, I am in my room in the hotel, right? Radisson Hotel. One police in the rank of DSP from Manipur comes to my room, right? Very pretty looking, good looking. She thinks that Chandru is also good looking. Okay? Just for a moment, don't think otherwise. And this lady comes for the purposes of arresting Chandru. And she takes a paper and writes, Chandru sir, you have stolen dash. Can I fill it with my heart or your heart? What heart? Is this grounds of arrest, my dear? But she has communicated something. She is investigating a case where Chandru has stolen something. But the communication is incomplete. Excellent. This is what was said by the Honorable Supreme Court in State of Bombay versus Atmaram. 4 judges bench, 1950. Please jot down State of Bombay versus Atmaram. ATMARAM. 1950 Supreme Court. 4 judges. Grounds of arrest communication is for the purpose of enabling the arrestee to defend him. It is not an ornament. Understand, my dear? It is a sacrament. It is not an ornamental thing. Grounds of arrest, see, in my state, Madras, what do the police do? You have committed an offense under 103, that's all. Is it a sufficient grounds of arrest? Whether any man who has committed a murder knows what is 103? Even if it is a 103, which 103? I would have committed 5 murders. A grounds of arrest means simpliciter should tell, Chandru, you have committed the murder of your wife Chandrika at Madras on so and so date. You understand, my dear, what is communication of grounds of arrest? That is, what is the crime this fellow is accused of, that's all. If this is missing, then you can take it for sure that the magistrate is not going to remand this person and will let him on bail. No doubt, if it is an offense under PMLA or UAPA or NDPS, whatever it is, bereft or dehors the gravity of statutory bar also, if grounds of arrest is not communicated in a communicable form, in writing and signed by him and received, then make sure 2 things will happen. That man will go on bail. Your superior officers will sue you for dereliction of duty. Always remember, there is one provision where superior officers are also bound to everything under law, that is section 30 of BNSS, which is equivalent to 36 of Criminal Procedure Code. You can never take a defense that it is my subordinate who has done that. Parents patria concept. If son is good, it is okay. If son is bad, then who is held vicariously responsible? Who is held responsible? Father. Like that, always remember that a superior officer is bound to do the job of an officer down the line as per section 30 of BNSS, equivalent to section 36 of this thing, CRPC. Okay. Now, I will give you some judgments. Try to jot down. If not, there is, I think videos will be circulated. AG sir, we will circulate videos to them. Yes. The foundational judgment every prosecutor, every judge, every policeman should understand is Woolmington versus DPP. Woolmington, W-O-O-L. Every prosecutor, every defense lawyer, every police person should be knowing this. This is the foundational judgment. Woolmington versus DPP, Directorate of Public Prosecution, dated 23/5/1935, House of Lords. Woolmington versus DPP, 23/5/1935, by House of Lords. Okay, what is the importance of this judgment? Point 1. A question was raised before the House of Lords whether prosecution is duty bound to prove the case beyond all reasonable doubt. It was answered by House of Lords in positive, yes. Whether accused shall be presumed to be innocent, yes. This was a judgment prior to independence when India was a colony with the British people. This judgment, the ratio is consolidation of 2 concepts. That is, prosecution should prove the case beyond all reasonable doubt. Accused shall be presumed as innocent. These 2 concepts were reconsolidated and laid down by the House of Lords that all colonial countries governed by Britishers will be governed by this law. Till date, Supreme Court is following this Wilmington, it is because of this prosecution is duty bound to prove a case. It is because of this Wilmington judgment every accused in this country is presumed to be innocent. So this judgment has got two concepts. Apart from this judgment also deals about reverse burden of proof. That is cases like POCSO, section 29 and 30, NDPS, UAPA also, and 304B, read with 113, capital A and B, reverse burden of proof. Reverse burden of proof is not a concept where the accused should prove the case first. Even in a case of reverse burden of proof, who should prove the case first? Who should prove? Prosecution. Why? Section 101, illustration small a of Indian Evidence Act. 101, illustration small a says, prosecution should prove the case. Reverse burden is, if the prosecution has proved a case as against the accused and there are incriminating circumstances in the form of 313 questioning, after 313 is over, then reverse burden shifts on him. It is his duty to disprove the case of the prosecution. Please don't think, understand or confuse that if there is a reverse burden of proof, then the accused should prove the case. Even in that case, prosecution should prove the foundational facts. Only if the prosecution proves the foundational facts, then only the burden of the accused comes in. Okay, my dear? These are all the foundational things. Okay? Then, two other important judgments I will tell you. What for? There is one concept called as burden of proof. I was talking about reverse burden of proof. One another concept is burden of proof. The foundational judgment of this burden of proof is Commonwealth versus John W. Webster. Commonwealth versus John W. Webster. This is the first judgment of Massachusetts Court, United States. See, we are all, every day, every prosecutor is confused what is proving a case beyond reasonable doubt. The concept of beyond reasonable doubt was coined by a Massachusetts courts of United States in Commonwealth versus John W. Webster. Only if you understand all these concepts, only if police understand this concept, then you will be in a position to advise the PP. Only if PP understands all these foundational aspects, then he can aid the judges. Only if judges clear in all this foundational issues, then only deliverance of justice will be done. Okay? Commonwealth versus John W. Webster, 1850, Massachusetts Court, United States. Then Charles R. Cooper versus F. W. Slade. Charles R. Cooper versus F. W. Slade. A judgment of 1857, House of Lords. This is with regard to preponderance of probability. There are two concepts. In criminal law, what is the proof? Burden of proof. Civil law? Preponderance of probability. This judgment, Charles R. Cooper versus F. W. Slade of 1857, is the judgment which propounds the theory of what is preponderance of probability. So these are all fundamental judgments. Okay. Now we will go to section 35 to 62. 35 to 62 of BNSS deals with what? 35 to 62 deals with arrest. Okay. Before understanding what is section 35 to 62, every prosecutor, every police person, every defense lawyer should know what is section 4 and 5 of CRPC or section 4 and 5 of BNSS. What is section 4 and 5 of CRPC or BNSS? Section 4 says, CRPC is the procedural law for penal code, IPC. Section 5 says, if there is a special law, then procedural law will be the special law. I am repeating, section 4 and 5, every day we are expected to read what is section 4 and 5. 4 says procedural law for IPC offences is CRPC. Now, BNSS is the procedural law for BNS. Section 5 says for special law like PMLA, POCSO, UAPA, NDPS, if procedure is imbibed, inbuilt in that act itself, then special law will prevail over general law. How many of you are not married here? Only one person. 2. My God, only 3 not married. Then how will be the population little in this place? Only 3 out of 600, 500 people. I am also raising my hands. I am also not married. Right? Yes. Brother, who is the queen in your house? Not married. Who is the queen? Mother. See, age is a fair man. The junior advocate is not answering. He has got some hesitation. I think he is in love with some woman. I am asking who is the queen in the house. He is not replying. So 2 queens. See, I said I am not married. Who is the queen in my house now? Mother. Suppose Chandru is in love with Chandrika. All these are imagination. Don't go to greater imagination. Okay? Yes. Yes. Suppose Chandru gets married to Chandrika. Who will be the queen immediately? Chandrika. What will happen to the old mother? Chandrika will see to that mother escapes out of the backyard. Not even the front house. Right? Now, general laws are like old mother-in-laws. Special laws are like newly married daughter-in-laws. Section 4 and 5, if you understand a mother-in-law and daughter-in-law properly, you will understand 4 and 5. Right? 4 says, mother-in-law, that is CRPC, will rule IPC, or IPC and CRPC will govern each other. Like Chandru and his mother. 5 says, generalia specialibus non-derogant, that is, special law will prevail over general law. And there are certain laws which says, special law and general law will walk together. Rarely it happens, no? Daughter-in-law and mother-in-law walking together. I do not know about Manipur. Mostly what will happen? Special law will say that I will prevail over general law. So you should understand all investigating agency, all prosecutor, every time you take a law, special law or a general law, you should first go and read what is 4 and 5. You cannot invoke CRPC or BNSS for every special law. Because in special law, special procedures will be followed. You understand, my dear? Okay? Yes. Having seen this 4 and 5, now we will come to section 35. What is this 35 to 62? 35 says, power to arrest. Power is given not only to police, power is given to so many investigating agencies in this country. Power to arrest whom? Power to arrest an accused person, not an offender. What is the difference between offender and accused, my dear? What is the difference between an offender and an accused? Yes. Who can declare that the accused is an offender? Who can declare? Only the court. When? After a... Excellent. You are just beautiful. Good people. Intelligent people. Right? Policeman, a complainant can accuse somebody. Can accused. Right? Can accuse somebody. Policeman will say he is accused. Police will file a charge sheet. A PP like me will assist the court in the realm of finding the fact. Right? We prosecute. It is only the court in this country which will declare that this accused is an offender or a convict. No one else can call anybody as an offender. Right? A person, if prosecution has proved the case beyond all reasonable, court will say that you are guilty of the offense, or I am convicting you, or you are an offender in this case. 3 words I have used: guilty, convict, then offender. Okay. 35 says you are dealing with not an offender, not a guilty, not a convict. 35 is simpliciter. A accuses B of an offense. The duty of the police is, as per 35, you can arrest the person for the purposes of getting along with the or getting forward with the investigation. Whether police has the right to arrest? Yes. Whether police has the power to arrest? Yes. When they can arrest, how they can arrest, what is the purpose of arrest, or questions writ large before us that has irked the conscience of the Supreme Court from 2023 till for the past 3 years. The conscience of the Supreme Court is troubled much because investigating agencies are misunderstanding or mistaking themselves that my power to arrest is like a power of a Hitler to do anything. Supreme Court says we are all ruled by what? Rule of law. Supreme Court says existence of power to arrest is not equivalent to exercising power to arrest. Power to arrest exists. That doesn't mean you should exercise always. You understand, my dear? What is the difference? Power to arrest should be explained with necessity to arrest. If every prosecutor, every police person in this country understands this one concept, there will not be much human rights violation. You are in a stage of accusation, right? An informant comes and says that Chandru has snatched my chain. That's all. You have that information with you. Now 35, which is erstwhile 41 of CRPC, now it is 35 of BNSS, says if the offense is punishable for a punishment of 7 years or less than 7 years, give him a notice. Let him come and answer for the accusation. This notice is called as what notice? 41A notice, or now it is called as 36 notice. This notice is mandatory that it should be served on the accused. Right? Now, if the complainant goes to the police station and says, Chandru has snatched my chain. Complainant gives Chandru's number. Okay. Now, police serves the 41A notice by WhatsApp. Chandru's phone itself is not working. Right? They will say, they will type a message, then they will say, you should come and appear. And they themselves will write in CD that Chandru was served with a 41A notice of CRPC or 36 BNSS notice, 36 subsection 3 notice of BNSS. Now the Supreme Court in Satender Kumar Antil versus CBI, please note this very carefully, all police officers and prosecutors. A notice under 41A CRPC or 35 subsection 3. 35 subsection 3 should not be served in electronic mode. It should be served personally on him and not in an electronic mode because it involves his personal liberty. No doubt BNSS has given the authority to serve all the process in an electronic mode. Supreme Court says courts can serve summons through electronic mode, but not police, more so if it comes to a service of notice under 35 subsection 3, which is equivalent to 41A notice. This was laid down by the Honorable Supreme Court in Satender Kumar Antil versus CBI 2025, my dear. Satender Kumar Antil starts from the guidelines of Supreme Court in Satender Kumar Antil starts from 2022, 23, 24, 25 and 26. What is 26 judgment? 26 judgment is a collaborative judgment of South and Northeast. What do I mean by that? When I was a very small boy studying in school and college, there will be vehicle which is called as Hero Honda into Suzuki. What is Hero Honda? Honda belongs to which company? Japan. Hero? India. Ind Suzuki. Suzuki is Japanese. Ind is India. Like that, what has happened in Satyendra Kumar until versus CBI said it is a collaboration of South and Northeast. My Lord's Honorable Justice from Madras High Court, now in Supreme Court, Justice M.M. Sundaresh from South and Justice Koteswar Singh from our Manipur, both of them have given this judgment in Satyendra Kumar until versus CBI 2026. What do they say? I will read for gain for a moment. See, please understand this one judgment. You will have a greater clarity with regarding to arrest. Right? What do they say? This is 2026. What is the date? 15/1/2026. Satyendra Kumar Antil versus CBI. Judgment of the Honorable Supreme Court by Justice M.M. Sundaresh and Justice Koteswar Singh. Right? Madras and Manipur. Wisdom of Madras and Manipur. I am reading the concluding portion. Para 33. On the basis of the interpretation given by us, we conclude as follows. An arrest by a police officer is a mere statutory discretion. It is not a compulsion or a mandate on your head that you should arrest every Tom, Dick and Harry just because an FIR is pending on you. Right? It says an arrest by a police officer is a mere statutory discretion which facilitates him to conduct proper investigation in the form of collection of evidence and therefore shall not be treated as mandatory. Then para B, 33 small b. Consequently, the police officer shall ask himself the question as to whether an arrest is a necessity. I have told you, power of arrest, nobody can say you do not have the power to arrest, but every station house officer should be advised by the superior officer, enjoying the parents patria concept that my child, please listen. See, I am addressing you as in the capacity of a teacher, I am calling you as you all as dear, right? You superior officers can also call your subordinates as dear, but don't call them secretly in the phone as dear, right? Then some criminal cases will be given, harassment, Posh will come. Right? Call them as dear in the public. Consequently, the police officer shall ask himself the question as to whether an arrest is a necessity or not before undertaking the said exercise. If you venture to arrest a person, ask a question, what is the necessity that I am doing this? Am I doing this in abuse of my power? Is somebody compelling me to do that? Or am I doing that for some ulterior motive? Or I am vengeful? What is the purpose? See, satisfy your conscience. It is after all our conscience which will not retire from this body till death. All your uniforms will get retired. Yes, my dear? A judge of a Supreme Court will retire at the age of 65. High Court judge? 62. All police officials, military people, all will retire, right? You cannot even touch your uniform the next day of retirement. If you touch the uniform on the next day of retirement, in which hospital you will be admitted? Which hospital? Mental hospital. By whom? Your own sweet wife. She will call the police and tell, please come, this fellow has become mad, he got retired yesterday evening, now he is taking the uniform. All these attires are adorned on us for protecting our fellow men, right? We are not fighting against Pakistanis or Afghan people, right? It is our people, our citizens. See, all this power is given only for the purposes of protecting our people, right? Our citizens, to have a smooth social order. Don't think that our brothers are criminals, right? We are all very good people. I will ask a general knowledge question which Honorable Justice P.N. Prakash has asked in this very same Manipur court last time. Justice P.N. Prakash, a giant in criminal law, posed a question to all the young advocates who were present last time. Tamil Nadu, the population is 8 crores. We have got lot of jail, prison in Tamil Nadu. Right? Anybody from prison here? No? Prison department? Anybody from home department? No? Any IAS officers is here? Any IPS officer? Yes. Didi, you should answer this question. Out of 8 crores in Tamil Nadu, Didi, what will be the population of prison? Including convicts, under trial, everybody. Anybody? Didi, first preference is to Didi. What will be the population in jail? Out of 8 crores in Tamil Nadu.
Sir, maybe 50,000?
Who said 50,000?
This side. On the left side.
On the left. Yes.
Maybe 50,000.
I will give you half chocolate. So what should be the answer? 25,000. Out of 8 crores of population, only just a meager marginal thing of 25 people are under trial, convict, blah, 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 whatever it is. So this is a nation which enjoys peace. We are all good people. We are all not born criminals. We are not born terrorists. Right? So much of hue and cry is not necessary in this country. Have that in mind. Okay. Then a notice under, I am reading once again 30, Satendra Kumar Antil versus CBA 2026, right? A notice under section 35(3) of BNSS to an accused or any individual concerned for offences punishable with imprisonment up to 7 years is the rule. The code says in 2026, what is the rule? If a person is accused of an offence punishable for 7 years, arrest is not the rule. Issuing notice not through electronic mode is the rule. 25 and 26 Satendra Kumar Antil. Then even if the circumstances warranting an arrest of a person are available in terms of the conditions mentioned under 35(1)(b), arrest shall not be undertaken unless it is absolutely warranted. All these are the wisdom of Honorable Justice M.M. Sundaresh and Justice Koteswar Singh of the Supreme Court in 2026, 15 January 2026. So, my first submission before this August gathering is, Supreme Court, the guidelines of the Supreme Court is, hasty arrest is not a civilized or moral policing. A civilized nation will not put everybody into prison. See, so imagine, put yourself in that place, whatever your position be, right? If some other agency comes and takes you off from your home for no offense, what will be your mindset? How people would have looked at you, looked upon you or looked down you. This is the yardstick which you should follow with everyone in this country. Okay? Yes. Now, I will give some judgments of the Honorable Supreme Court starting from, please jot down Joginder Kumar. This is a case where an advocate was taken by the police and the whereabouts of advocate was not known for 7 days. Advocate's relative went to the High Court, filed a habeas corpus. You know what story police said? Police, like advocates, are experts in writing stories. Even cinema directors will fail in front of us. You give me a small line, I will give a big plaint or a big writ petition. Like that, you give one word to our police friends, they will write. What they will write? See, a poor lady comes to me for a small matrimonial discord as against her husband. How many cases I am drafting? One is DVC, second 498A, then a 406, then a divorce, judicial separation. If an advocate can manipulate one fact into multiple facts, like that, if a small issue is before a police, then police will write all stories. There will be an old head constable, retired head constable also. In Tamil Nadu, we are hiring retired head constables. What for? In police station. What for? Writing stories. Because elderly people are familiar in writing stories like that. Right? So don't write any stories like that. An advocate was taken into custody. What did the police say to the court? Police said, this advocate is assisting us in a crime investigation for 7 days. No, read Joginder Kumar. I am not joking. Supreme Court said, go and say all this story to somebody else. So this is the case of the Honorable Supreme Court, that arrest should not be hasty. Grounds of arrest has to be stated. It all started in Joginder Kumar versus State of UP 1994. Then also read the judgment of Arnesh Kumar versus State of Bihar, which is in 2014. Please read Arnesh Kumar guidelines. Arnesh Kumar is not only with regard to 498A, it is for any offence which is punishable less than 7 years. Along with Arnesh Kumar, read the judgment of Rajesh Sharma versus State of UP 2017. Social Action Forum Manav Adhikar, Social Action Forum Manav Adhikar versus Union of India 2018. Then once again, Shivangi Bansil versus Shahi Bansil 2025. Shivangi Bansil versus Shahi Bansil of 2025. What does this judgment says? Rajesh Sharma of 2017 says, I said you should read Arnesh Kumar along with these 3 judgments. Rajesh Sharma versus State of UP 2017, then Social Action Forum versus Union of India 2018. Once again, Shivangi Bansil. Rajesh Sharma versus State of UP 2017 says, you police should not register FIR under 498A. This is a division bench judgment. Social Action Forum judgment, a full bench judgment, said 498A is a cognizable offence. FIR should be registered. Right? Court should not say FIR should not be registered. This was in Social Action Forum. Once again in 2025, a division bench of the Supreme Court says, if it is a matrimonial dispute, case is filed as against 498A, no FIR should be registered. Case should be referred to family welfare. I do not know, only the senior advocates here should say, when Social Action Forum, a 3-judges bench has said something, can Shivangi, a 2-judge bench, once again say something against that? I just leave it to the August gathering here. So the present law is, Shivangi Bansil's case says, if a woman comes to the police station, lodges of FIR under 498A, hasty registration should not be made. Case has to be referred to a welfare counseling center. Okay? It should also be read with Satyendra Kumar Antil, CBI 2022, 23, 24, 25 and 26. Any question of arrest and bail, any lawyer on the either prosecution or on the defense pollers, you should take printout of Joginder Kumar, Arnesh Kumar, then Sakri Vasu as a State of UP 2007. Please read, every police person and the prosecutor, the defense should read Sakri Vasu as a State of UP. That is, every action of the police is supervised by whom? Jurisdictional magistrate. Every action of the police is under the supervision of the jurisdictional police, and for any aberration of the police, you should approach the jurisdictional magistrate under 156.3 of CRPC. Now it is 175.3. Okay, 156.3, now it is 175.3 of BNSS, Sakri Vasu. Then coming down of Sakri Vasu is another judgment of Siddharth as a State of UP. Please jot down Siddharth as a State of UP. Siddharth as a State of UP 2021. In this case, the Supreme Court says, and dear police brothers and sisters should please note down, if charge sheet is laid down under section 170 of CRPC or 190 of BNSS, you should not arrest a person. Okay? If charge sheet is filed under 170 CRPC or 190 BNSS, then you should not arrest a person. Before the arrest, charge sheet should be handed over to the Magistrate. Magistrate also should not compel that this person should be arrested and brought before him while charge sheet is filed before the court. Then please also read the judgment of Muhammad Asfaq Alam versus State of Jharkhand 2023 regarding arrest and bail. Muhammad Asfaq Alam 2023. Right? Then parameters for grant of bail. From arrest, we will just for a moment go to the parameters for grant of bail. What are the parameters for grant of bail? The court will assess what is the crime, gravity of crime, what is, see, you have asked me in the questionnaire what should be the objection that we should raise, right? For that I will give you some judgments. Court will always take into consideration what is the crime, who is the criminal, what is the severity of the offense, what is the gravity of that, what is the impact of the offense on the society. All these the court will assess before granting bail. I am repeating: crime, who is the criminal, severity of the offense, gravity of the offense, impact of the crime on the society, and whether it is an offense simpliciter under general law, that is BNS or IPC, or is it an offense under a special law. I have told you in the very beginning, special law will deserve a special consideration from the court because Parliament has carved out a special circumstance in the form of a special law. So there will be bar under the special laws. For example, POCSO. Please jot, 29 and 30 presumption will start from the very beginning. 29 and 30 of POCSO, presumption that he has committed the offense and he has got a guilty mind, 29 and 30. Then with regard to UAPA, 43D5. What is 43D5? 43D5 says of Unlawful Activities Prevention Act, UAPA, it says court shall not grant bail. What is the twin condition? Court should come to a conclusion that this person, there is no prima facie case as against him. Only if the court presumes that there is no prima facie case, then only court can grant bail in UAP offences. This is 43D5. Come to 37 of NDPS. It uses the word court shall not grant bail. Once again, court shall not grant bail. Court should give a recording that he is not guilty of the offense. He will not commit an offense in the future. Two things, twin test. See, normal general law, section 436 of CRPC says, court shall grant bail in bailable offences. See the word which is used by the Parliament. 436 says, court shall grant bail in bailable offence. Investigating agency can grant bail in bailable offence. 437, court may grant bail in non-bailable offences. That is, it lies in the reasoning ability of the judicial officer to grant bail or not to grant bail. For both he should write what? To grant bail, what the judge should write? What? He should write an order with reasons. Correct. What is a reasonable reason, my dear? Once again, chocolate is there. What is a reasonable reason? Any reason which is accepted by a superior officer is a reasonable reason. Right? A magistrate writes an order. Chief Judicial Magistrate says, Acha. Then it becomes a reasonable order. And the PDJ says, very good. It becomes a reasonable order. High Court also accepts. Then it becomes a reasonable. Morning, my lords. Okay. So reasonable reasons has to be written in every order by a judge while releasing a person on bail. Okay. Yes. I will give you some judgments where parameters of grant of bail is established. What is it? State versus Captain Jagjit Singh. State versus Captain Jagjit Singh, 1962 Supreme Court. Then Guru Charan versus Delhi Administration, Guru Charan versus Delhi administration, 1978 Supreme Court. Ram Govind Upadhyay versus Sudarshan Singh. Ram Govind Upadhyay versus Sudarshan Singh, 2002. Kalyan Chandra Sarkar versus Rajesh Ranjan, 2004. Kalyan Chandra Sarkar versus Rajesh Ranjan, 2004, Supreme Court judgment. Then His Holiness Jayendra Saraswati Swamigal, versus State of Tamil Nadu, 2005. P. Chidambaram versus CBI, 2019. Please have these 5 to 6 judgments. All these are landmarks where the Honorable Supreme Court, starting from Captain Jagjit Singh till CBI versus Chidambaram versus P. Chidambaram versus CBI, the Honorable Supreme Court has said what are the parameters for grant of bail. This is with regard to an offense under IPC or BNS. I have told you already that special statutes are governed by special procedures and special bars, right? POCSO, what are the provisions which says that this person is presumed to have committed and this person has a guilty mind? What are the provision? 29 and 30. UAPA 43 D 5. NDPS 37. SC/ST Atrocities Act 18. Read also 18 capital A. Okay. Does it mean that all these statutes bars the door of bail at all? No. It never says, as I have said, in NDPS it says, the court should come to a finding that he is not guilty and he will not commit offense in the future. See, can anybody say that Chandru will not commit an offense tomorrow? Can anybody say that SP will not become a criminal tomorrow? Can anybody say a judge will not become accused tomorrow? How can now the court come to a conclusion under section 37 while granting bail, judge should write 2 reasons. One is, he is not guilty of the offense. That doesn't mean that the judge is sifting evidence. Prima facie, it appears that he is not guilty. See, this is not a verdict after post-trial, after trial. This is apparently on the materials collected by the investigating officer, right, from the inception of FIR till charge sheet. You understand, my dear? Right? What is the test? You should read one judgment in Ranjit Singh Brahmajit Singh Sharma. Very beautiful judgment. You can admire and love this judgment. Ranjit Singh Brahmajit Singh Sharma versus State of Maharashtra, 2005 Supreme Court. Yes, my dear. How long? We'll finish? 5 minutes? 5 minutes? Yes. Ranjit Singh, Brahmajit Singh Sharma versus State of Maharashtra, Supreme Court says, what is the test for the question that he will not commit an offense in the future? Right? What is the test? Anybody here? Before marriage, right, you will go to the bridegroom's house or bride's house. The broker, the agent in between will say he is a good boy. How do he comes to such a conclusion? Through what? A person is assessed as a good person through what? Through his past antecedents. A person is concluded on the, see, today somebody says I am good because of my past antecedents. Supreme Court says what is the test is his criminal antecedents in the past and the propensity to commit any offense in the future. These 2 tests. Okay. So This is the yardstick. So special statutes doesn't say that bail will not be granted at all. I will give you some 2 or 3 judgments under UAPA also. It is NIA versus KA Najib. Any person who is appearing on the defense side will give the judgment. NIA versus National Investigating Agency, Union of India represented by NIA versus KA Najib. This is a 3 judges bench judgment. Supreme Court. Any person like me on the prosecution side will give the judgment of Gurdeep Singh versus State of Punjab. Where Supreme Court has laid down Gurdeep Singh versus State of Punjab, Supreme Court has laid down that jail is the rule, bail is the exception in special cases. I am repeating, Gurdeep Singh versus NIA, a division bench of the Supreme Court has laid down that jail is the rule, bail is the exception. Subsequently, in Gulfi Shah, Gulfi, not Kulfi, K-U-L-F-I is Kulfi. This is G-U-L-F-I, Gulfi Shah Fatima versus Union of India, 2025. Honorable Supreme Court has said, even in special statutes, court should adapt accused-centric approach for granting bail. It is not that for special offences bail should not be granted, or because it is a special statute, bail should be denied. What the accused side will say, he will say that 21 is there, release me under bail. Supreme Court says in Gulfi Shah Fatima versus NIA that a balanced approach is required. However, because of the inconsistencies between Nazim's case and Gurvinder Singh's case, in Taslim Ahmad versus State of Punjab, 2026, Supreme Court has referred it to a full bench. Okay. Then regarding, you have asked me some questions regarding arrest of foreigners. No special. See, Article 21 doesn't discriminate between citizens and foreigners. I will just give you one judgment of the Honorable Supreme Court, a latest judgment. The Customs versus Farida. Customs versus Farida, F-A-R-I-D-A-H, Farida. Nakanwagi, N-A-K-A-N-W-A-G-I, Nakanwagi. This is the latest judgment, 2025, by Honorable Justice Pardiwala and Justice K.V. Vishwanath. If you read this one judgment regarding how to handle a foreigner, this judgment will do. That is, in simpliciter, I will put you, there is no distinction between a person committing an offense who is a foreigner and a person committing offense in India, an Indian. Because Article 21 says no person. It includes citizens and foreigners also. Then what will happen? How to grant bail for whom? Who will be the sureties? Supreme Court says, if at all he cannot give any sureties from this country, how a foreigner can give a surety in this country? In this, Supreme Court says, take a personal bond, let him on bail. However, letting him on bail is not a visa for letting him out of the country. Whether this person should be let out of the country or not will be decided under Section 3 of the Foreigners Act of 1946. You are clear with this, my dear, because multiple questions are there. You have asked me questions that we are in border place. People from the other states, that is foreign countries, are intruding and troubling. How bail has to be granted? Bail, please read this judgment. You can grant bail, but they living out of the country, leaving the country is in the exclusive domain of the authority under the Foreign Registration Act. Okay, 1946 Act. Okay, any other questions? My time is over. Any other question? Yes, ma.
Sir, could you be kind enough to elaborate on the term prima facie, because you just narrated a series of sections in special legislations. So in terms of when the judicial officer is exercising the discretion in all the special provisions that you have narrated,
I will explain.
Prima facie.
Okay, I will explain. See, I am appearing as a special public prosecutor for NIA in Madras High Court, right? The cases will be with the second court. I was opposing a bail last week. The court put me a question. You establish, because there is a bomb blast, how do you say that this comes under UAPA. What is the question? The court has asked me a question, what is the offense? I said, a person, daylight in Pondicherry in 2023, 2 bombs were hurled on him and multiple using machetes, that is knives with heavy knives. Multiple injury was made to him. He was smashed, that fellow was smashed. Within 17 seconds, less than a quarter of a minute, 17 seconds, 6 men murdered him on a daylight in a place which is called as Villanur in Pondicherry. And you should see the terror that it has caused. The first terror is, when this fellow was murdered, this deceased house is situated 2 kilometers away from the scene of occurrence. People are running hither and thither through the streets of that village and with great cry and panic. The wife came out and said, what is the problem? They said that your husband was killed. Now, the jurisdictional police took this as a murder case. However, the central government, using suo motu powers under section 6(3), read with 8 of NA Act, thought fit that because an explosive substance was used and terror was made in the minds of the people, you should invoke UAPA. NIA should become the investigating agency. The question posed by the honorable bench is how this case was tried by NIA. Under section 6(3) of NIA Act, central government can suo motu take any case provided there is an offence committed under the schedule of the Act. Or if the central government feels that a terror was caused in the minds of the people, then NIA can come as an investigating agency. Then NIA goes in, re-registers the case, gives a fresh FIR number, and NIA takes evidence on the line of terror committed by them. So now the mere terror and using bombs, explosives, gives a prima facie case. Now at this juncture, court should not go and find whether there are materials to convict under the UAPA or Explosive Substance Act. My High Court, in yet another judgment, please read, because you asked me what is prima facie, read a judgment of Union of India represented by NIA versus Barakatullah. Right? This is a judgment from Madras High Court where the Honorable Supreme Court has said, during appreciation of bail, you should accept the prosecution case as it is. One thing is whether prima facie is made out or not. You cannot go into the evidentiary value of the materials. Okay, my dear? Yes, I will give my number and email ID also. You can trouble me. A question should be limited only with what? Legal this thing. One client has sent me a message, how is that you are growing long hair? That is the reason with this caveat I am telling. I will finish this with a small joke. I appeared for a wife. Husband is attributing an adultery as against her. Judge is staring at me. I really got worried. That judge, in Pondicherry, one judge by name Kalidas, a man of great morals. He was staring at me. So many butterflies are flying in my stomach. I was worrying how to defend this lady. Right? Not 1 or 2 adultery, multiple adulteries. I came out, I am telling some 10-15 years back. At that time, I will not put all this. It will be flowing. Right? This girl, when I went out, she is telling, Chandru sir, how is that you are growing such a long hair? I was worried how to defend my client. My client is worried about my... Okay, thank you so much. All credit should go to my senior who has taught me law, Mrs. Vrinda Mohan, and to my parents. I want to say a few words about Honorable Justice Nirmal Kumar, who is sitting here. I know I am a small dot in front of him. As I have told already that he is a great colossal on criminal law, he is a great human being. In this very same Manipur, last time I came with Honorable Justice P.N. Prakash. My Lords Nirmal Kumar was taking class on trial. Honorable Justice P.N. Prakash told me, Chandru, I am telling because things good has to be said. He said, Chandru, a man who is above all small human infirmities, you cannot put this man under any small limitation. Secondly, he said, Justice Nirmal Kumar wrote several exams, got cleared all the exams, was in multiple government service in Tamil Nadu, finding that he cannot be put down with, finding that he cannot work there without corruption. He has resigned every job, came back as an advocate. Finally, it is the destiny. God has made him as a judge, High Court judge. This was told to me by Honorable Justice P.N. Prakash last time in this very Manipur. I am very proud. My sincere pranams to my lords. We all will follow his footsteps. We are proud that a man with such integrity, honesty and knowledge, very, very humble, down-to-earth person. 3 days back, my junior appeared for High Court Legal Services in a NDPS case. Every time I just admire him in the court, which happened 3 days back also. My junior was just doing some drama in the bundle because he has not come prepared. My lords had said, in a NDPS case, what you should see. I learnt a lot 3 days back. He said, you should see provisions relating to section 40, section 50, section 57. Arrest, search, seizure, sample collection. That's all. Here is a judge. The humanity is of such nature that he will find, if an advocate stands in front of him, he will find whether the advocate is read or not. If he concludes that the advocate is not prepared properly, he will say, please wait. Then what he will do? He will read. No, I am not joking. We cannot, I do not know whether I will have that much of patience and humility. He will read thoroughly. You cannot see him without a pencil. He will read thoroughly. Refer books frequently, even for small provisions, because mistakes should not be committed. He will take notes, and whatever you have argued, whatever the other side has argued, will be in the judgment. Great man. You are all fortunate to have such a tall person here. Thank you so much. I love you all. Thank you, my lords.
Thank you very much, sir, for reflecting minute details of the provisions of criminal law and constitutional law. Sir has analyzed the various case laws of judicial pronouncement of Supreme Court of India. Thank you once again, sir. Now we have the tea break for 15 minutes. So there is a slight change in the timing. So I request all the participants to kindly reassemble at 12. Thank you once again. Hello. Good afternoon, everyone. We are about to start the program in another 5 minutes. So program hogdine kenom to ningsing jage participants me am the resource person na haidi stage lak piba matam da haidi just round of applause amutang tawbiro haidi ngarang jo mokoi kitang ai khoide haibi rame ba haidi kuba am to khobi rakte na haidi. Good afternoon, everyone. May I request all the participants to kindly take their seats as we are about to resume the academic session. For this session, the resource person will be joining through online mode due to her technical or personal problems. And it's now my honor and privilege to introduce our next distinguished resource person, respected Ma'am Sonia Mathur, senior advocate, Supreme Court of India. She is widely admired for her outstanding contribution to criminal law, constitutional litigation, and human rights jurisprudence. Her extensive experience before constitutional courts makes her one of the country's most eminent legal practitioners. Ladies and gentlemen, please join me in welcoming respected Ma'am Sonia Mathur with a warm round of applause. May I respectfully invite respected ma'am to address the gathering via online. Thank you once again.
Thank you very much for a very kind introduction. First of all, very warm greetings to the honorable judges, all the dignitaries who are present here, respected government secretaries, judicial officers, learned law officers, members of the police department, distinguished members of the bar, ladies and gentlemen. At the outset, I would really like to express my sincere thanks and sincere gratitude to the Honorable Chief Justice of the High Court of Manipur, the Government of Manipur, the Manipur Judicial Academy, and all the organizers for inviting me to address this distinguished gathering. It's indeed a privilege for me to interact with an audience who, in their respective capacities, are entrusted with one of the most sacred responsibilities under our Constitution, which is the administration of criminal justice system. My apology for not being there physically for some unexpected personal reason that I had to miss this precious opportunity of visiting your state, which is often celebrated as Jewel of India. I would look forward to any other opportunity which I may get in near future. I must congratulate Mr. Chandrasekharan for very ably explaining all the provisions with very in-depth reasoning and great clarity. And I also will try to, being a second speaker, I would have some limitations, but I'll try and avoid all overlapping. I've struck down already from my note. If anything, I tend to overlap. My apologies to the audience for boring them on a Sunday afternoon. And so far as time is concerned, I'm sure the organizers will find some way of pointing out to me if I cross my time. So most of it is very ably covered already. So I'm just crossing whatever. Now the section 35 to 62 had already been covered by Mr. Chandrasekharan. So now I'll just briefly touch on the procedure for effecting an arrest, which are the statutory safeguards under the BNSS. Now, first point that comes to my mind is section 36 of the BNSS, which says identification of the arresting officer. Now, every police officer effecting an arrest shall bear accurate, visible, and clear identification of his name and designation. The object of this is to ensure that there is clear accountability. The arrested person should know identity of the person who's depriving, identity of the officer who's depriving him of his liberty. Now, and second is, of course, the memorandum of arrest. There are statutory requirements which are required to be followed when a memorandum of arrest is being made. Now, all these, once in 1997, D.K. Basu versus West Bengal was taken by the Honorable Supreme Court. The citation is 1997 1 SCC 416. Now, most of the safeguards which we've already discussed, which Mr. Chandrasekharan had discussed, and also which are part of the statute, owe their origin to the most important constitutional judgment, which is D.K. Basu versus State of West Bengal. Now, there were various mandatory safeguards which were prescribed by the Honorable Supreme Court in that judgment. If I can just briefly touch upon them. Now, one is, of course, the identification of the arresting officer. Second is preparation of memorandum of arrest. Then prompt intimation of the arrest to a friend, relative, or any other person. Communication of the place of arrest and detention. Informing the arrested person of his right to have a friend or relative notified of the arrest. And maintenance of contemporaneous record, including diary entries regarding arrest and the person who's been informed, etc. And then medical examination at the time of arrest. It also, in that judgment, the Honorable Supreme Court also said that periodical medical examination every 48 hours should be done. Now, so far as when initially Parliament had incorporated several of the D.K. Basu safeguards into the Code of Criminal Procedure, the provisions such as 41B, 41C, 41D, and 50A were brought in the statute book. Now, the law with regard to arrest and the safeguards with regard to arrest and bail, which are required to be followed by the investigating agencies, are very evolving, because with the development of technology and with now today technologies are a part of our day-to-day life. So depending on the advancement in our day-to-day life, even the procedural safeguards have to be developed accordingly. So even currently, the Honorable Supreme Court is presently also considering a miscellaneous application which is filed in D.K. Basu's case, which is the petition criminal 539 of 1986, and where further directions are being sought by the applicant there. And so therefore several important issues are presently engaging the attention of the Honorable Supreme Court, which basically are intended to ensure compliance, effective implementation of the provisions which are introduced under the BNSS, which are aimed at improving early access to legal assistance immediately after arrest, enhancing transparency during interrogation through technological and institutional measures. Now, it may also, if I may just mention this, that a very important question relating to the presence and access of a lawyer during police investigation and interrogation is currently engaging attention of the Honorable Supreme Court in case of Shafi Mathur versus Union of India. Can make a note. It is writ petition criminal 401 of 2025. Now, the date of hearing, which is indicated on the website, is 24th of July. It is, of course, subject to what finally happens. Now, to my mind, these proceedings reflect a very important constitutional message. The conversation today has moved way beyond merely asking whether safeguards exist in law or no. The focus today is on whether these safeguards are actually working on the ground or no. The court's endeavor is always to ensure that the constitutional promise of Article 21 is translated into meaningful protection at every stage, which starts from arrest and interrogation to remand and trial. Now, there's another very important component of our criminal justice system, which is right to free legal aid. The constitutional importance of free legal aid was first recognized by the Supreme Court in Hussain Khatun versus Home Secretary, which is 1981 SCC, page 98, where the court said that free legal aid is an indispensable component of a fair, just, and reasonable procedure under Article 21. Accordingly, where an accused is unable to engage counsel due to indigence, the state is under a constitutional obligation, not as a matter of charity, but as a mandate flowing from Article 21 and Article 39A to provide competent legal assistance at its own expense. Now, in the Honorable Supreme Court in Khatri 2 versus State of Bihar, which is 1981, 1 NCC 627, clarified that the obligation to provide free legal aid arises from the very first production before the magistrate and not merely when the trial commences. In fact, one of my cases where a death sentence were awarded to the accused, and they were not able to, the lawyer which was given to them by the court due to strike was not able to appear. So Supreme Court has taken note of the fact that if there was strike and if the lawyers were not appearing, the court should have gone out of the way and made sure that there is effective legal representation for the accused during the trial. And this has been one of the important factors which has weighed with the court while acquitting the accused who were initially awarded death sentence. Now, so far as the power of arrest under special statute is concerned, Mr. Chandrasekharan had broadly touched so far as the provisions are concerned, which are 43A, B, etc. I'll just mention a couple of judgments which you may note down, which would be relevant. It's Prabir Purkayastha versus State of NCT of Delhi, which is 2024 8 SCC 254. Now, this was a case where the Supreme Court says that Article 22, Sub-Article 1 requires that the ground of arrest be communicated in writing to the arrested person. Relying upon its earlier decision in Pankaj Bansal versus Union of India, the Supreme Court held that this requirement applies equally to arrest under the UAPA. Since the appellant had not been furnished the written ground of arrest, the court declared both the arrest and the order of remand as illegal. And the court also observed that the subsequent filing of charge sheet in the case would not cure the illegality which was committed at the inception of arrest. The second judgment, which is a latest judgment, is Mihir Rajesh Shah versus State of Maharashtra. This is 2026 1 SCC, page 500. Now, in this case, the principle which was laid down in the earlier judgment, which is Prabir Purkayastha, was further expanded. And the court held that the requirement of furnishing the ground of arrest in writing is not confined only to special statutes, such as UAPA or the PMLA, but constitutes a constitutional mandate to all arrests. And it further clarified the written ground should not only be conveyed, but it should be supplied in a language which is understood by the arrestee, so as to enable him to effectively exercise his constitutional rights, including seeking legal advice, opposing remand order, and applying for bail. And failure to furnish written grounds in a language which is understood by the arrestee would be a serious dent on the case of the prosecution. And court recognized that a narrow exception in cases involving immediate operational exigencies, where oral communication at the time of arrest may suffice, provided that the written grounds are furnished within a reasonable time and in any event not later than 2 hours before the accused is produced before the magistrate for the remand. Now, so far as the present situation is concerned with regard to this, confusion with regard to the ground of arrest to be given in writing, etc. Now, this issue is engaging the attention of the Honorable Supreme Court. In case of State of Meghalaya versus Sonam Raghuvanshi, this is SLP criminal 11944 of 2026, wherein the court has observed that has taken note of the conflicting decisions of coordinate benches and has indicated that the issue may require consideration by a larger bench. The court noted that apparent divergence between Pankaj Bansal, Prabir Prakayustha, Mihir Rajesh Shah, and Vihan Kumar, particularly on whether written communication is an indispensable constitutional requirement or no. Now, until an authoritative pronouncement is given on this issue by the larger bench, the investigating agency should be well advised to adopt the higher standard of procedural fairness by furnishing the grounds of arrest in writing so far as it's possible, and also in a language which is understood by the arrestee, while maintaining contemporaneous record evidencing such communication. Now, so far as PMLA Act is concerned, it has already been touched upon by my friend, the earlier speaker. So far as the special statute, which is arrest of public servant, is concerned under the Prevention of Corruption Act, there is this a question which is frequently asked is, does the law relating to arrest operate differently when the accused is a public servant? The answer would be both yes or no. The answer is no, because public servant enjoys no immunity from arrest, merely by virtue of holding a public office. Once the statutory requirements for arrest are satisfied, he is subject to the same constitutional safeguards and the same criminal procedure as every other citizen. At the same time, the answer is also yes, because the law recognizes that the public servant discharges official functions involving policy decisions, administrative discretion, and public administration. Therefore, the Parliament has provided certain additional statutory safeguards not to protect corruption, but to protect bona fide decision making. And the best illustration of this are a couple of provisions under the Prevention of Corruption Act. Now, I have been a standing counsel for CBI in Delhi High Court for a long time, so therefore I've dealt with several public law matters involving government decision making. And I have also found that the Prevention of Corruption Act seeks to maintain a very delicate balance between protecting honest public servants where they have just been involved in a fair decision making. At the same time, and these statutory safeguards cannot become a shield against the genuine allegation of corruption. Now, when it comes to arrest, for an ordinary citizen, an arrest primarily affects his personal liberty, but for a public servant, it means much more because it has two very distinct consequences which a public servant faces in case of arrest. First, of course, the ordinary consequences under the criminal law are attracted. Second, it may also entail consequences under the applicable service rules. Most service rules provide that where a government servant remains in custody for more than 48 hours, he is ordinarily placed under deemed suspension. So therefore, an arrest, unlike a public servant who, when he's out on bail, he can, to a certain extent, except for, of course, civil consequences, he can resume his normal life. But when it comes to a public servant, arrest may immediately affect not only his liberty, but also his employment, reputation, and career. So, and of course, the arrest may trigger departmental proceedings in addition to the criminal prosecution. There are two distinct jurisdictions. A criminal court determines criminal guilt on the standard of proof beyond reasonable doubt, whereas a disciplinary authority proceeds on the standard of preponderance of probability, as we've discussed in the preceding session. So ultimately, whether the accused is a private citizen or a public servant, the guiding principle remains the same. The power to arrest is an extraordinary power to exercise not as a matter of routine, but only when the law, the facts, and the Constitution justify these actions. Now, I'll refer to certain judgments in a bit, but now Satendra Kumar Antik has already been referred. Now, the parameters for private persons and public servant when it comes to the bail are concerned. So the parameters for a public servant would be the tampering window, if we see when the bail is considered. The tampering window for a private person usually is restricted to personal or local networks. But when it comes to public servants, there is a high risk of destroying official records or intimidating subordinates who can be potential witnesses. And of course, sanction for prosecution. For a private person, there's no sanction required. Prosecution starts immediately. As opposed to that, there is mandatory sanction required before the court take cognizance. Now, the custodial need, that has to be evaluated based on physical recovery of items or weapon when it comes to a private person. But when it comes to a public servant, it is frequently required to unearth institutional scams or financial trades. Socio-economic impact I have already referred to. Now, there is one issue which is mostly, I have also experienced as a defense lawyer also, that once a person is in custody and is interrogated, usually the bail is opposed by the prosecution on the ground that he's not cooperating with the investigation. Now, when a person is in custody, there is no question of non-cooperation. An accused is certainly not supposed to sing the song that the prosecution wants them to. So therefore, the courts usually say that to qualify for a non-cooperation despite the person being in custody, the courts usually say that, okay, you give a questionnaire to the accused and solicit answers on that questionnaire and make an assessment. Then the courts normally, while considering the bail, would make an assessment on the basis of the answers which the accused gives in the questionnaire. So that's one way of assessing so far as the Brahmastra available to the prosecution of non-cooperation is concerned. Now, Supreme Court has repeatedly reaffirmed that bail is the rule and jail is an exception. Jalaluddin Khan versus Union of India is a judgment of 2024, where this principle was again reiterated, and the court sought to strike a balance between an individual's right to personal liberty and interest of criminal justice. When we talk about recording the reasons or recording the grounds of arrest and making the arrest memo, which is completely in conformity with the statutory provisions, I would say that it is actually not really in the interest of the accused, but it is also equally in the interest of the investigating officer who's doing his job in a bona fide manner. So tomorrow, if the arrest is challenged, then the only ground on which an honest investigating officer can really defend himself that he's confirmed, he's complied with all the provisions is by maintaining this contemporaneous record, which is more than the accused. I think it is also to protect the interest of the honest public officers. Now, right to speedy trial is another issue where the court, while considering the bail, do also examine as to how long the trial has taken. If it's a long incarceration and the trial is not taking place the way it should be, and it ultimately amounts to defeating the right to speedy trial, then the courts do consider this as a ground for bail. Now, so far as bail in bailable offences is concerned, Section 478 of BNSS talks about bailable offences. So, according to Section 21C of BNSS, which was Section 2A of the CRPC, bailable offence would mean any offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. Accused can claim bail as a matter of right if he is accused of committing a bailable offence. In bailable offence, it is the duty of the police officer or the court to intimate the accused about his right to get bail. Thus, in bailable offence, liberty is the rule and detention is an exception. In the case of Rasiklal versus Kishore, this is AIR 2009, Supreme Court 1341. The Supreme Court held that the right to bail for bailable offence is an absolute and indefeasible right, and no discretion can be exercised at the words of Section 436 CRPC and Section 478 BNSS are imperative, and the person accused on offence is bound to be released as soon as the bail is furnished by him. And the court further observed that there's no need for the complainant or the public prosecutor to be heard in case where a person is charged with a bailable offence. Now, when it comes to non-bailable offences, Section 480 of BNSS talks about non-bailable offences, where it says that the bail is not a matter of right, but lies within the judicial discretion. And normally the court examine, as we all know, like we all come from the same background, we all know that what are the considerations when the court is examining the bail. Parameters are the nature and gravity of the accusation, severity of punishment upon conviction. This was also one of the grounds which were given in the case of Sanjay Chandra, which is a milestone judgment when it comes to bail. That was a judgment in 2G scam cases, where I happened to be one of the prosecutors. And of course, the possibility of the accused absconding, likelihood of tampering with evidence or influencing witnesses, antecedent, and also criminal history. Larger interests of society and administration of justice. Now, Section 480 BNSS, which corresponds to Section 437 of the CRPC, also recognizes special considerations in favor of women, children, sick or infirm person. Now, the other aspect of bail is also default or statutory bail, which was, of course, Section 167 of CRPC. I'll just refer to a judgment because we all know the concept of statutory or default bail. The Supreme Court in State versus T. Gangireddy, this is 2023 4 SCC 253, reiterated that default bail is a statutory right accruing to an accused solely because the investigating agency has failed to file the charge sheet within the prescribed period. It is not a determination on the merits of the prosecution case. The court in this case further held that once released on default bail, the accused is deemed to have been released under the provisions governing regular bail, and therefore such bail may be cancelled under the applicable provisions if strong and compelling ground exists. However, merely because a charge sheet had been filed after grant of default bail by itself will not be a sufficient ground to cancel the default bail which is granted to an accused. The additional circumstances will have to be placed by the prosecution which would warrant cancellation, including material which demonstrate the commission of serious non-bailable offence during the time when the accused was on default bail. Now, with regard to anticipatory bail, Gurbakh Singh Sabia is one judgment, which is the milestone, and more recent judgment is Sushila Agrawal versus State, which is in the context of anticipatory bail. The citation is 2025 SCC page 1, where the principal issue which the court was dealing with was whether an order granting anticipatory bail should invariably be limited in duration, and should it come to an end once the accused appears before the trial court or is summoned to face trial. Now, this question was answered by the Constitution bench by saying that there can be no inflexible rule requiring anticipatory bail to be time-bound. Ordinarily, once granted, the protection may continue till the conclusion of the trial, unless it is limited by the court for special reasons or is cancelled or legally recognized grounds. Meaning, once given, it would be available unless the court granting the anticipatory bail restricted in terms of time by recording reasons for doing so. Reiterating the constitutional philosophy in Gurbakh Singh Sabia, the court held that the anticipatory bail is an important safeguard of personal liberty under Article 21, and its duration must depend on the facts and circumstances of each case rather than any rigid time frame. And more recently, in the case of State of UP versus Muhammad Arshad Khan, 2025 INSC 1480, Supreme Court cautioned the High Courts against routinely granting blanket protection from arrest while declining to quash an FIR. This was a case where the court had declined to quash FIR, and once you say, and Supreme Court said that once a prima facie cognizable offence is disclosed and the FIR is not quashed, then protection against arrest must ordinarily be sought through the statutory provision of anticipatory bail and not by way of exercising writ jurisdiction of the High Court under Article 226. The court said the judicially imposed timeline for completion of investigation should be the exception rather than the rule, and may be issued, because in this case the court had said that the investigation be completed in 90 days' time and the anticipatory bail was granted. So the Supreme Court frowned on those observations to say that timelines cannot be imposed for completion of investigation. These should be exceptions. A significant change under the BNSS is the express bar on anticipatory bail in specific sexual offences. Section 482, subsection 4 of BNSS, which corresponds to Section 438, subsection 4 of CRPC, imposes a statutory prohibition against granting anticipatory bail in the cases where rape on a woman under 16 years of age is committed, which is Section 65(1) BNS 2023 and Section 376(3) of IPC. The corresponding section was 376(3). And also gang rape on a woman under 18 years of age. This was under the BNS, it's a Section 70, subsection 2. And then when we talk about bail, there's another concept of interim bail. Although there are no specific provision under the BNSS which prescribe grant of interim bail, but the concept of interim bail has evolved entirely through judicial decisions. Now, interim bail is granted only as a temporary measure pending disposal of an application for regular bail or even anticipatory bail. So in Kamlendra Pratap Singh versus State of UP, 2009, Volume 4, SCC 437, the Supreme Court reaffirmed that a judge considering a regular bail application has the inherent authority to grant interim bail while the bail case is being decided on its entirety. There have been cases where the prosecutors have objected to interim bail being granted on the ground that there is no provision under the law which really prescribes for interim bail, so it cannot be granted. In case of Arvind Kejriwal versus Director of Enforcement, the Supreme Court had also emphasized with regard to the grant of interim bail that it's not governed by any rigid formula, but depends upon the peculiar facts and circumstances of each case. In this case, in the case of Arvind Kejriwal, the interim bail was granted to enable the Chief Minister of Delhi to campaign during 2024 Lok Sabha election, and the court recognized that the decision must balance individual liberty with the interest of justice, taking into account factors such as the nature of allegation, the conduct of the accused, and any compelling circumstances. Then, of course, the next concept of bail is transit bail, which is again not expressly codified in any criminal law, but it has become a very vital legal tool. It basically offers a temporary protection from arrest when a person is located in one state but faces arrest in another. The individual can approach a local court and seek transit bail to travel to the jurisdiction where the case is registered and then apply for regular bail or anticipatory bail as advised. So this is basically, it's only to ensure the procedural fairness across the state boundaries. Despite the lack of explicit statutory recognition to these concepts, the Indian courts have consistently upheld the power to grant transit bail. And in Supreme Court in Priya Indoria versus State of Karnataka, this is a judgment which is reported in 2024 for SCC 749. While recognizing the constitutional imperative of protecting personal liberty under Article 21, the court held that the High Court or the Court of Session may grant transit anticipatory bail where the applicant has a reasonable apprehension of arrest in connection with an FIR which is registered outside the territorial jurisdiction. Now, this relief is purely interim in nature and intended to only enable the applicant to approach the competent court having jurisdiction over the FIR for seeking appropriate relief. Now, the court in this case also emphasized that the transit anticipatory bail is not a substitute for regular anticipatory bail and must be granted for a limited duration. Like we just saw in Sushila Agarwal, the court said that there is, unless specified, the bail anticipatory bail would continue and will not automatically end when the accused appears before the court. In this case, the court specified that the transit bail would be very temporary for a limited duration and subject to appropriate conditions. Now, there is, of course, a concept of bail pending appeal, which is suspension of sentence, which is earlier it was 389 CRPC. Now, certain judicial safeguards, I will not mention in detail, just one lines and some judgments. Kindly pardon my throat. Now, judicial safeguards which govern the exercise of bail jurisdiction. One is, of course, bail is the rule and jail is the exception. Supreme Court has repeatedly reiterated as one of the most enduring principles of Indian criminal jurisprudence. This principle was first articulated in Gudikanti Narsimhalu versus Public Prosecutor in 1978 by SCC 240, and it is now reaffirmed in numerous subsequent decisions, including Sanjay Chandra versus CBI, which is 2012, 1 SCC, page 40, and of course Satyendra Kumar Antil versus CBI, which is 2022, 10 SCC, page 51. Now, this principle basically reflects on the constitutional commitment to personal liberty. The rationale is simple yet profound so far as this principle is concerned. And the reason for that is that an accused person is presumed innocent till he is proven guilty. So, detention before conviction is justified only where it is necessary to secure the administration of justice and, of course, conformity with the rule of law, which we discussed about in the preceding session. Bail cannot be refused merely because the allegations are serious or because public sentiment demands a punitive response. The court must always ask whether the objective justice can be achieved without continued incarceration. Now, public sentiment is a very, very risky proposition when it comes to offenses which mostly involve moral turpitude or the sexual offenses, because that's where the public sentiment is charged to its maximum. And these are the considerations which cannot be allowed to weigh while denying or granting bail. The Sanjay Chandra was a case which is outcome of 2G scam cases. Of course, it led to ultimate acquittal, although appeal is pending before the High Court. But as of today, they were acquitted. So it was in that context that the court had observed that bail cannot be given as a punitive measure. This is the second principle which I wanted to highlight, that bail cannot be refused as a punitive measure. Because until such determination is made, whether a conclusive determination is made with regard to guilt, every accused enjoys the presumption of innocence. So therefore, pre-trial detention cannot be used as a substitute for punishment. The third principle is protection against arbitrary arrest and mechanical detention. Then the concept of default bail. The court says that default bail, which is the CRPC was section 167 subsection 2 and the BNSS is section 187, it's an absolute indefensible right against prolonged investigation. The judgment which I wish to refer to in this context is Rakesh Kumar Paul versus State of Assam, which is 2017, 15 SCC, page 67. And this principle has been reaffirmed in the context of special statutes in Muhammad Ariz Hasnain, alias Ariz Hasnain versus State of Jharkhand. This is 2026 SCC Online, Supreme Court, page 80. In this case, Supreme Court held that the extension of time for investigation under the UAPA is not a mere formality. The public prosecutor's report and the court's order must reflect due application of mind, and the accused must be afforded an opportunity of hearing. Mechanical extension of time cannot defeat the accused's indefeasible right to default bail. In the case of Ritu Jhabadia versus Union of India, this is the Supreme Court judgment, 2024, 12 SCC, page 116. In this case, Supreme Court held that the investigating agency cannot defeat the statutory right to default bail by filing an incomplete or piecemeal charge sheet within the prescribed period. So unless a complete police report under section 173 subsection 2 CRPC is filed, the accused continued to be entitled to default bail. This next principle is protection of under trial prisoners against prolonged incarceration, which I mentioned in the context of right to speedy trial. And so wherever there is delay in investigation, delay in commencement or completion of trial, or even inability to furnish bail or sureties, the courts have stepped in to protect the rights of the accused. In Bhim Singh versus Union of India, which is 2015-13 SCC, page 605, the court directed Chief Judicial Magistrates and the session judges to hold periodic sittings in prisons to identify under trial prisoners who are eligible for release under 436 capital A of CRPC, which is now section 479 BNSS, to facilitate their release without unnecessary delay. The court also carried this reform forward in inhuman conditions in 1382 prisons. This was a case which was suo motu registered recognizing that overcrowding in prisons is primarily attributable to the large number of under trial prisoners, noting that Section 479 BNSS is more beneficial than the erstwhile Section 436 CRPC. The court directed all jail superintendents to proactively identify eligible under trial prisoners and move the competent courts for their release upon completion of the prescribed period of detention. There are so many prisoners. I'm also a part of the NALSA, and we realize that there are so many prisoners who don't even know that they have been granted bail. They just continue to be incarcerating. They are not aware that bail has been granted because they are not able to manage the sureties, etc. Now, this is the next principle which I wanted to talk about: protection of indigent accused and effective implementation of the bail orders. The Supreme Court repeatedly recognized that many accused persons continue to remain in prison even after having gotten the bail because they are unable to furnish sureties, arrange bail bonds, or there is nobody for them to complete the procedural formalities. Recognizing that the grant of bail often does not translate into the actual release, the Supreme Court, in Policy Strategy for Grant of Bail, in Re 2024 10 SCC 685, the Supreme Court issued series of directions to remove procedural and systematic hurdles faced by under trial prisoners. The court directed that every bail order should be electronically communicated to the concerned jail superintendent without any delay, who must immediately update the prison records. Where an accused is not released within 7 days, despite the grant of bail, the jail superintendent is required to inform the Secretary of District Legal Service Authority, who must then provide assistance through paralegal volunteers or jail visiting advocates to facilitate the prisoner's release. In fact, I have come across a case where the appeal has come till Supreme Court. The person is in custody, and of course, as a senior counsel, I'm not to be interacting with the accused, but the advocate on record, the person who was interacting with the accused, told me that the accused had come forward to tell him that when he was sentenced or when he was convicted for this offense for which he was undergoing prison, he was not even there. He was undergoing sentence in another case. So this was a fact. This was easily verifiable by the lawyer pursuing his case or by the court itself. But there's nobody to represent him or nobody to even tell the court that he was not even there. He was in custody at that time. And that person is today undergoing jail, and the appeal is pending in Supreme Court. And he's gone through so many years of incarceration because he was not aware of his legal rights. He was not probably having the effective representation before the courts. So in this case, when we're talking about this policy strategy for grant of bail, the court also directed district legal service authorities that they have to assess the socioeconomic condition of the accused through probation officers or paralegal volunteers and place an appropriate report before the court so that onerous bail conditions or surety requirements may be suitably relaxed wherever warranted. In appropriate cases, the courts may also consider granting temporary bail to enable an accused to arrange bail bonds or sureties. If bail bonds are not furnished within 1 month of grant of bail, the court should suo motu revisit the matter and consider whether bail condition requires to be modified. The Supreme Court also emphasized that insistence on local authorities often results in unnecessary incarceration and observed that wherever possible, courts should avoid imposing such conditions. There have also been a number of cases that are personally dealt with by me where the courts, the amount imposed is so much that the person concerned under no circumstances is in a position to pay. And there have been cases where even 5,000 amount they are not able to pay, and with the result they continue to be incarcerated. Then, of course, one provision which has the effect of releasing the convict is remission. which is remission is generally referred to as reduction or mitigation of a sentence that has been imposed on a person who's been convicted of a crime. And this provision allows the reduction of the period of imprisonment or other penalties, etc. Now, what is the objective of remission? This is actually an executive decision, and it has judiciary has nothing to do with this. It is only the state. So, in remission, duration of the sentence is reduced without changing the nature of the sentence. The prisoner is released with or without conditions. And in the eyes of law, he's a free man technically, but yes, he continues to be a convict for the rest of his life. But of course, he's out of custody. And this is actually not an act of charity or compassion. The law prescribes for this, and remission is something which is earned by a prisoner. There are certain conditions which are prescribed in law, subject to a prisoner meeting those conditions, and of course, the 14 years parameters. The convict, the prisoner, becomes eligible to be considered for remission by the state. And so far as the statutory provisions concerning remission are concerned, Section 473 of BNSS 2023, and earlier it was Section 432 of the CRPC. Now, this grants state governments the power to remit sentence at any time with or without condition. Non-compliance with condition can lead to cancellation of remission and also rearrest without a warrant. Section 475 of BNSS, which was earlier 433 of CRPC. Life convicts which are sentenced for offences punishable by death cannot be released before completing 14 years of imprisonment. The jurisprudence on remission has been significantly strengthened by the Supreme Court in Policy Strategy for Grant of Bail 2025, INSC page 239. In this case, while interpreting Section 432, which is now 473 of BNSS, the court held that the appropriate government has a continuing obligation. Now, this is important. It says the appropriate government has a continuing obligation to proactively consider the cases of all eligible convicts for premature release in accordance with the applicable remission policy, without insisting upon a formal application by the convict or his family. So therefore, the state is on its own expected to take the cases where the convict or where the prisoner has become eligible to remission. The court further directed the states and union territories lacking a remission policy to frame one, emphasized that order granting or refusing remission must be reasoned and promptly communicated to the convict, and reiterated that remission cannot be cancelled without affording the convict an opportunity of hearing. The court also entrusted the district legal service authorities with monitoring the implementation of these directions so that eligible prisoners are not deprived of the benefit of remission merely on account of administrative inaction by the state authorities. Now, if I can just refer to some of the judgments which may be relevant. Now, the first judgment is Dondial versus State of Rajasthan. It is 2026 INSC 599. This was a case where the appellant convict was sentenced to 4 years of rigorous imprisonment. A single judge of Rajasthan High Court granted him parole and subject to furnishing a personal bond and two sureties. Now, despite fulfilling these conditions and the sureties being verified to the court's satisfaction, the jail authorities did not release him. He remained in custody for a period of 24 days beyond his entitlement. Now, there was a habeas corpus petition filed to secure his release. He then approaches the Supreme Court. Release is made by the Honorable High Court. He approaches the Honorable Supreme Court seeking compensation for a period of unlawful detention. The state argued that the delay was due to administrative process and that it was considering challenging the parole order itself. So Supreme Court rejected this argument and held that the 24 days continued detention was illegal and awarded 11 lakh compensation under Article 21. So the proposition which I'm trying to make here is that continued detention, even after verification of parole surety, is completely illegal and violates Article 21. So compensation of 11 lakh was a public law remedy which was available to the convict. The second case is State of UP versus Muhammad Arshad Khan. This is 2025 INSC 1480. And the proposition which I'm trying to advance here is that High Court's jurisdiction is properly framed under Article 226 read with Section 482 CRPC, and judicially fixed investigation timeline must be reactive, not prophylactic. In this case, an FIR was registered under Section 420, 467, 468, 471 IPC, and also under the Arms Act. Now, this person, Muhammad Arshad Khan, he was alleged to have procured 5 separate arms licenses using forged PAN card, Aadhaar card, driving license, documents, and also misrepresentation of his date of birth, etc. Now, he approached Allahabad High Court under Article 226 seeking quashing of the FIR. The High Court relied on its own decision and declined to quash the FIR, but directed that the investigation be completed within 90 days. This was the judgment which I referred to in the earlier segment, that the investigation was directed to be completed in 90 days. However, the court went ahead and granted the accused protection from arrest in the interregnum. And the state appealed against this decision before the Supreme Court. And Supreme Court held that while declining to quash an FIR, the High Court cannot routinely grant blanket protection from arrest or impose time-bound directions for completion of investigation. Judicial timelines are warranted only upon demonstrated delay or stagnation in investigation. The protection from arrest must be sought under the statutory remedy of anticipatory bail, but not by way of a writ or a quashing petition. Then another judgment which I wanted to place before you was Dhanji Pandey versus State of Bihar. This is 2026 INSC 349. This was a case where the respondent number 2 here, he was convicted for murder and allied offences and sentenced to life imprisonment. During pendency of this appeal, Patna High Court suspended the sentence under Section 389 of the CRPC and released him on bail. The informant, the complainant, challenged this decision before Supreme Court. Now, the Supreme Court set aside the High Court's order suspending the sentence and held that suspension of sentence in murder cases is an exceptional relief and can be granted only where a palpable infirmity in the conviction is apparent. An appellate court cannot reappreciate evidence while considering suspension of sentence, and mere long incarceration or pendency of the appeal is not by itself a sufficient ground for granting such relief. Now, the proposition here is that sentence suspension under Section 389 CRPC is only justified where a palpable infirmity is apparent on the face of the record, especially in cases of a case of murder, where the person is convicted under 302 and sentenced to life. Then Ritu Chabadia, I did mention about this case in the earlier part. Ritu Chabadia versus Union of India. This was a case, it is 2024-12 SCC 116. In this case, during investigation, this is in the context of default bail. During investigation, CBI filed successive supplementary charge sheets without completing the investigation, and the accused custody was continued without his getting the default bail. Supreme Court held that an incomplete charge sheet does not defeat the right to default bail under Section 167(2). Now, however, this matter is still pending because by an order dated 12/5/2023, a 3-judge bench directed that pending default bail application be decided independently and without relying on Ritu Chabadia, pending the Union of India recall review proceeding, because the Union of India had filed a review proceedings in this review petition, So that part is still pending. But so far as this facet of Article 21, which is the default bail, is concerned, this was upheld by the Supreme Court. And when we talk about bail in the special statutes, I think that this has been discussed in detail, just that the judgment with regard to the grounds of arrest, Pankaj Bansal versus Union of India is one judgment, which is 2024 7 SCC, page 376, where Supreme Court has held that the ED must furnish a written copy of the grounds of appeal. And then Prabir Purkastha, where 2024 8 SCC 254, where the appellant here was director of NewsClick. He challenged his arrest under the UAP on the ground that the ground of arrest were not furnished to him before his police remand. So Supreme Court held that the grounds of arrest must be communicated in writing at the earliest. Failure to do so would violate Article 22, Sub-Article 1, vitiate the arrest and remand, and entitles the accused to release. Now, before I come to the end, there is just one thing I would like to share with you with one thought. One aspect of it is significance of sessions such as this, which can help us educate each other and keep us updated, since the law by itself is a very evolving concept. And I'm digressing from the topic, my apology for that. And the other part, which is a beautiful illustration to say that our criminal justice system is not only concerned with protecting the rights of an accused during arrest and investigation, but is also equally committed to safeguarding the dignity and rights of the victim. So one aspect is that sessions such as what we have today, the significance and importance of such sessions. And the second aspect of what I'm referring to is the rights of a victim. I'm sure all of you would be familiar with the practice of two-finger test, which was being done at one point in time on survivors of sexual assault, which is this practice was actually a stark reminder of how investigative and medical procedures can sometimes inflict secondary trauma on a victim. Now, modern medical science has clearly rejected this practice as scientifically unsound, and the law has also recognized it as deeply violated of a survivor's dignity, privacy, and bodily autonomy. Way back in 2013, in the case of Lilu versus State of Haryana, 2013-14 SCC, page 643, the Supreme Court had authoritatively and extremely clearly prohibited this practice completely. And it was held that it violates the survivor's fundamental right to privacy, dignity, and physical integrity, which is ensured under Article 21 of the Constitution. Now, it's more than a decade, I would say. Firstly, nearly a decade later, Supreme Court had to again express concerns in State of Jharkhand versus Shailendra Kumar Rai. This is 2022-14 SCC 299. The Supreme Court again expressed concerns that the practice continued despite having been settled. The court reiterated that any person conducting such tests would be guilty of misconduct and directed the union and the states to ensure that the guidelines issued by the Ministry of Health and Family Welfare prohibiting this practice were to be strictly implemented. Now, despite all of that, in one such incident that I had to come across was in a case which is Sunshine Kharpan. This was in 2024, where I had an occasion to appear, and the court expressed deep concerns over the continued use of this practice. And this was despite the fact that there was a circular, there was a rules issued by the state government. Despite that, this practice was being followed. So Supreme Court expressed great anguish in this. So therefore, what I'm trying to convey here is that these kind of sessions which is being held by the Manipur Judicial Academy and state of Manipur, are extremely important. I mean, I would have really loved to be physically there, to be little more interactive in the session, but due to some unavoidable personal issues, I could not make it. But however, I am available if there is anything that anytime anybody wants to talk to me about. Now, in my years of at the bar, and significant criminal practice has really taught me that every criminal case at its core is about human lives. Behind every file is a victim seeking justice, an accused asserting legal rights, and an investigating agency performing a public duty, and a court entrusted with maintaining a delicate balance between the two. It is this balance, which is founded on fairness and the rule of law, that this is what that give legitimacy to our criminal justice system. I have had a personal experience of noticing as to how the every case has a human life, has a human heart behind this. And there was one case where the convict was sentenced to death, and the death sentence was given by the trial court, upheld by the High Court. They were in Supreme Court. I was appointed as amicus in the case, and they were acquitted finally. And when the judgment of acquittal was passed, the counsel on record connected me to mother of one of the accused. Now, in front of me was mother of the victim who was subjected to rape and was killed. So in front of me, there was mother of the victim with tears in her eyes, who had, I'm sure, complaints. And on the other hand, on the phone, I had mother of one of the convict who was sentenced to death, but ultimately acquitted. So out of happiness, she was crying. So there was one mother on one end, and the other mother on the other end. So that made me realize that how each case is not just about law. Every case has a heart. So therefore, I only want to say in the end that whatever procedural safeguards are required to be undertaken, it is not only to protect the accused. I would say predominantly it is to protect the honest officers also. All contemporaneous record, I've seen it so many times, arrest memo, if it is not properly carried out, if it's not properly time-stamped or anything, then all discoveries consequent to those, everything falls apart. So therefore, small details are to be very religiously carried out. I am being given a signal by my colleague here that I've crossed my time. So I would just end here. If somebody has to say anything, I would be more than willing to answer. Otherwise, I'm truly grateful to the state and to the academy, and also to the Honorable Chief Justice for giving me an opportunity to be here. And I would really wait for an opportunity to be physically there and see the jewel of India myself. Thank you so much. Thank you.
Thank you so much, ma'am, for explaining and highlighting the nuances of legal aspects of criminal justice systems and constitutional safeguards under the arrest and bail, focusing on statutory procedures, constitution mandates and guidelines safeguarding personal liberty. Thank you once again, ma'am. Ladies and gentlemen, we shall now proceed to Module 4, dealing with procedures and safeguards under Preventive Detention Laws, including the National Security Act, prevention of illicit traffic under the NDPS Act. This session addresses one of the most sensitive domains of criminal jurisprudence, balancing individual liberty with national security and public order. It is now my humble privilege to introduce our resource person, Honorable Lordship, Mr. Justice M. Nirmal Kumar, Judge of Madras High Court. Lordship is widely respected for his profound legal acumen, impeccable judicial wisdom, and significant contributions to criminal jurisprudence. His Lordship's judicial pronouncement continue to strengthen the rule of law and promote constitutional values. Ladies and gentlemen, may I request everyone to extend a warm and respectful welcome to Honorable Lordship Mr. Justice M. Nirmal Kumar to deliver the lecture. Thank you, Lordship.
Good afternoon to all, my brothers and sisters. Today, the topic we are going to deliberate is Preventive Detention Laws, and predominantly which is NSA and PIT NDPS, and one more is Coffee Posa. Yes, when we say there are two types of, one is two types of action, one is preventive action and one is punitive action. Punitive action, we know that that person is identified as an accused or is a convicted person, and thereafter punitive action is taken. For punitive action, you need evidence and the case has to be finalized, also and so forth. But preventive action, it is an which is an act which has been done to prevent for forthcoming or anticipated or any disturbance of public order or for the safety of the integrity of the nation. So there is a vast difference between preventive action and punitive action. But everything, the rights of the arrestee or detainee, all stems up from Article 21 and 22. We all know Article 21 says that a person shall be deprived of his life or personal liberty except according to procedure established by law. And this procedure established by law is the hallmark of that has to be stressed. The procedure must not only be established by law, but it must be fair and reasonable. The procedure must be such that it is in conformity with justice, fairness, and reasonableness. You know that Maneka Gandhi versus Union of India AR 1978 SEC 597, which speaks about the procedure established of law. And as regards the preventive detention, both Article 21 and 22 has to be combined and it has to be viewed from that angle, both has to coexist. As regards Article 22, it is protection against arrest and detention in certain cases. 22(1) is with regard to arrested person must be informed grounds of such arrest and right to consult and to be defended by a legal practitioner. And 22(2), arrested person detained in custody shall be produced before nearest magistrate within a period of 24 hours. And 22(3) is nothing in clause 1 and 2 shall apply A, to enemy alien, B, person arrested or detained under preventive detention. So from here on, preventive detention excludes Article 22, 1 to 3. So for as regards the preventive detention, it is to be considered from Article 22, 4. Because the preventive laws have been enacted under Article 22(7). So that is the reason we have to understand the constitutional provision and constitutional safeguards which has been given for preventive detention. And all the preventive laws, whatever the laws and rules which has been introduced, it's based on the Article 22(4) to 22(7). Article 22(4) says that detention of a person not for a longer period of 3 months. That everybody knows. But there is a proviso unless the detention is advisory board is reported within this 3 months period, and 7A and B has to be followed. I'm just running out because after that we'll have a PPT. In that I will explain to you in detail. This is only an introduction. Article 4A is a preventive detention for more than 3 months permitted unless advisory board is of opinion sufficient cause for more than 3 months permitted. Advisory board is of opinion sufficient cause for such detention is justifiable. Article 22(5) grounds of detention. This grounds of detention is the bedrock of building up a preventive detention case and justifying your case and also justifying the detention of the person. This grounds of detention is the entire heart of your detention order. So this grounds of detention has to be understood in its rights perspective, and also all the ingredients for detaining a person under preventive law. This grounds of detention will only sustain your order when it is scrutinized in the court of law. And 5 states that a detained person, as soon as may be communicated grounds of detention, shall afford him earliest opportunity of making representation. So grounds of detention has to be immediately served to him, and their timeline is given. That will go ahead. And thereafter, the detainee is also to be given and informed that his right of making representation. And 6 is a saving clause to the detaining authorities, where to say that wherever if the authority considered to be against the public interest, so far to that extent, it can be withheld. As regards NSA, that is National Security Act 1980. Prior to it, prior to this act, you have this Coffee House Act of 1974, and thereafter NSA 1980 and PIT NDPS 1988. As regards NSA, this is what you all here in the state of Manipur. This is the most number of cases you will be dealing with, encountering, and facing the difficulty in convincing the court about the reason and your justification of imposing or clamping the detainee with NSA. Section 3 is the power to make detention orders. Section 3.3. And thereafter 3.1 states central government, 3.2 states about the state government, and 3.3 is the delegating authorities. Delegating authorities who has to clamp this detention order. With here district magistrates, that is the collectors, district magistrates, or the commissioner of police. As regards state of Manipur, I don't think so you have a commissioner of police, you don't have a commissioner of police, so it is district magistrates. And who is the detaining authorities? And the superintendent of police will be the sponsoring authority. And 3.4, section 3.4, the detaining authority forthwith to report to the state government the grounds of detention within 12 days. And grounds of detention to be served to the detainee after 5 days, but not later than 10 days from the date of detention. 3.5 is the state government shall within 7 days report the fact to central government along with grounds and the order passed with opinion of the state government to justify the necessity for the order. And section thereafter straight away other things are with regard to how the detention order to be served, and in absentia what to be done, and with regard to the other aspects and severity of the sections. Section 8, thereafter state important thing would be section 8. grounds of orders of detention. Grounds to be served within 5 days, not later than 10 days. Communicate and afford detainee the earliest opportunity of making representation to the government, which is akin to Article 22, 4, 5. And Section 9 says about the composition of the advisory board, the qualification of the advisory board, members qualification in the advisory board, and Section 10 reference made to the advisory board, that the duty of the government to, within 3 weeks from the date of detention, place it before the advisory board. That is the checkpoint. Whatever the order has been passed by the detaining authority, a checkpoint has to be given. So that is the advisory board is the checkpoint, because we all know preventive detention is imposed on a person. It is only for future, to safeguard the public safety, and without any trial or without knowing the what is the thing. A person without a trial, without a conviction, without analyzing of the evidence, he has been straight away detained. For that reason, the advisory board acts as a checkpoint. And government shall within 3 weeks from the date of detention place before advisory board the government to place the detention order, grounds of detention, detention order, representation, if any, from the detainee or his family members, along with report by government justifying the detention. And with regard to Section 11, procedure of advisory board, considering the materials placed and the requirement, call for further materials, and desire to be, if the detainee says that he wants to be heard, detainee to be heard, and after hearing him in person, to submit a report to the appropriate government within 7 weeks from detention. And thereafter you have Section 14, where it states that anytime the detention order can be cancelled. That is there. And PIT NDPS is also on the similar line, the same guideline, same thing, it's also on the similar line. Only thing is there will be 5 days, then 15 days, and 6 months. Those are the slight difference in the dates and the rights which has been given. Otherwise, it is almost akin, one and the same. And the purpose of initially, NDPS cases, the offenders were detained under Coffee Bosa. And from 74 till 88, it was only under Coffee Bosa only, drug offenders were detained. Thereafter, it was felt that since a drug trafficker, which he commits an offense within India, clamping Coffee Bosa, justifying that clampation was finding it difficult. Because Coffee Bosa primarily, it pertains to foreign money involved and the foreign reserve, and it's also trans-border issues were there. So with regard to an offender which has been committed by the drug offender within India, clamping him under Coffee Bosa was very difficult. For that reason only, there was a notification, I think it's Amendment Article 41 of 88. Thereafter, this PIT NDPS came into force from 1988, and thereafter, it has been held that for drug offender, it cannot be under Coffee Bosa, it will be only under PIT NDPS. Now, going into the PPT, it is with regard to legislative objectives about the 3 statutes, what I have given an output. One is Coffee Bosa, second is NSA, state security, foreign relations, and public order. And under these are the 3 grounds wherein NSA can be clamped. And this is now PIT NDPS, and where it has been taken away. It is with regard to smuggling, foreign exchange, again, abatement of smuggling. It is primarily on the economic aspects. Security of the state. We all know that three concentric circles that Supreme Court has held, three concentric circles. The outer circle is the law and order, inner circle is the public order, and the innermost circle is the state, security of the state. This is public order. This is what you normally use it for clamping NSA. It's not moving. No, again it's this is with regard to PIT NDPS. Yes. Yeah. Yes, as I initially opened my topic with regard to Article 21 and 22, both goes together, a dual cumulative test on every detention order. And this chapter sets out the clause by clause requirements and the foundational Supreme Court jurisprudence on grounds, communication, and right of representation. These are the requirements and how preventive laws have been enacted. The liberty must be, depriving a person's liberty must be reasonable, fair, and just, not merely the procedure prescribed by statute. Court looks through form to substance, provides targeted procedural projections, communications, right of representation, and advisory board review within 3 months. There are mandatory minimums, not aspirational standards. Yes, the burden of demonstrating that the liberty of a detainee has been taken away strictly in accordance with procedure established by law rests squarely on the state, and the state cannot shift the burden of the detainee. Hence, this is the difficulty where the detainee authority face, and it cannot be shifted at any point of time, and the detainee authority has to be their detention order must be grounded with facts, particulars, that all to be reflected in the grounds of detention. This Ram Manohar Lohia is the concentric circles, where in this case the 3 concentric circles of law and order, public order, and state security all would be explained. And just a run through what are the provisions. what we have seen earlier. Right one is grounds of communication. Detainee must be furnished with, this is for the detainee's right. The detainee must be furnished with the grounds on which detention order was made as soon as may be. That is an important factor. Grounds must exist at the time of order. They cannot be construed post facto. The grounds must be sufficiently particularized to enable a meaningful representation. Right of representation. The detainee must be awarded the earliest opportunity of making a representation against the order, directly dependent on and flowing from the first right without adequate grounds. Without adequate grounds, communication, the right to represent is illusory. And once grounds have been first furnished, there cannot be addition of grounds. And breach of Article 22(5), whether through delayed communication, non-supply of relied upon documents, or failure to translate invalidates the detention order without exceptions. Court do not engage in proportionality analysis. Once a breach is established, relief follows as of right. Likewise, once grounds are conveyed, no additional grounds may be added. Any addition either indicates grounds existed but were not communicated, it is a breach, and contribute to the state's satisfaction at the time of the order. Either it is fatal. Again, language of communication and non-supply of documents which you normally encounter. And with regard to getting yourself rectified or to sustain your thing, and after receipt of the, normally this will be raised in their representations. Once a representation in this form is received from the detainee or on behalf of the detainee with regard to the language and non-supply of documents, it is the detaining authority has an opportunity to rectify the same. Grounds of detention and all relied upon documents must be supplied in the language known to the detainee, not merely the grounds in isolation. The obligation extends to every document on which the authority has placed reliance. And the timeline, exceptions, and all exceptions must be by a written reason justifying the delay. We all know each day delay counts. And I think now in the modern days, the illegible copies is no more there. Normally, it has been, all copies furnished are being legible. Likewise, translation also must be proper. In Khudiram Das versus State of West Bengal, the definition of grounds of detention has been clearly explained. Grounds means the complete factual foundation of the detention order, comprising all basic facts, particulars, and relied upon materials that formed the detaining authority's subjective satisfaction. Because subjective satisfaction of the detaining authority is important, and it might vary from person to person, but your detention order, that is grounds of detention, must reflect the detaining authority's application of mind. This application of mind is an important factor where the this detention order will show the detaining officer's application of mind. It may not be very big, elaborate, but the concise form, all the important factors, all the important facts of the case to be reflected. Communication of grounds is mandatory because it alone enables the detainee to exercise the constitutional right to make an effective representation under Article 22(5). A representation made without knowledge of the full factual basis is not a meaningful exercise of the right, it is an empty formality. This is where the retaining authority has gotten in the considering the public interest to withhold the important or a portion of the vital facts, you can withhold it, but that cannot be taken as an shield to completely withhold the entire facts. This 1A, B, C, one is for security of India, public order, and essential service. Again, central government, state government, delegated officers. And subjective satisfaction or versus and, this plays an important role. And the subjective or the satisfaction must be say and. If it's going to be or, then it becomes speculative. Once it becomes speculative, the detention order will not sustain. And this 12-month cap and section 14 at any point of time they can withdraw. Acting in any manner prejudicial to the maintenance of public order requires a disturbance whose terror wave and intensity affects the community at large. This is the punch word which is required to be reflected in the detention order. Disturbance whose terror wave and intensity affects the community at large to justify and sustain your detention orders. Here only the delegated officers, normally it is the district magistrates or the additional district magistrate who are empowered, likely to make the detention orders. This is what normally has been done. See, subjective satisfaction of the state government on the circumstances prevailing or likely to prevail is a mandatory precondition. Use of or versus and in the delegation order is critical, and error vitiates the order for non-application of mine. This is revocation and passing of subsequent orders. Only condition is that within the same first period itself, the second period also to get over. Where a subsequent order is issued without fresh facts, the total permissible detention order that the subsequent order cannot exceed 12 months from the date of the original detention. What is colorable excise? A repeat order without new material is to challenge as a colorable excess of power. Here again, subjective satisfaction on existence of circumstances prevailing or likely to prevail is an essential precondition for conferring delegation on the detaining authority. Or versus and critical drafting point. If delegation is made considering both present and anticipated disturbance simultaneously, the conjunctive and must be used using or in this scenario renders the order obscure and vitiates for non-application of mine a frequently overlooked drafting error. It is PIT NDPS, again it is that is with regard to severity. revocation, again PIT NDPS is also on the same line, and highly vulnerable areas, Manipur comes under the highly vulnerable area because it's bordering Burma, and so you have got all the powers to clamp orders. This Gurbakh Sikh Bairani Union of India, wherein it has clearly said once grounds disclose illicit narcotics or psychotropic substances traffic, the PIT NDPS Act governs exclusively. Coffee Basa is jurisdictionally barred by proviso to section 3(1) of Coffee Basa. This is the role of advisory board and its limitation. A.K. Roy, a celebrated judgment. It's a detailed one. Gives the functions, advisory nature, temporal jurisdiction, legal practitioner, friends and relatives, detainee's own case. Function to determine whether there was sufficient cause for detention on the date of the order was passed and whether sufficient cost exists at the time of review. The board cannot project forward beyond its report date. The board's opinion is merely advisory, not subject to judicial scrutiny as an adjudicatory act. Its opinion binds the appropriate government only when it favors the detainee, a mandatory release obligation. The board cannot consider whether it is necessary to continue the detention beyond 3 months or beyond its report dates. Its temporal jurisdiction strictly limited the period ending on the date of its report. A detainee has no enforceable right to claim legal representation before the advisory board. The board retains discretion to permit legal representation in particular circumstances, must be raised before the board, not before the government. Yes, the legal representative, it is an important factor. Under what provision legal practitioner is permitted to be consulted and defended by the detainee or arrestee? We started with it. Which provision in Article 22? That is a fundamental in criminal law. 22? Yes, everybody are hungry. See, for every person and legal practice, you all know that legal practitioner is the only profession which is mentioned in the Constitution. And legal practitioner has been given, any detainee or arrestee is given a right to consult a legal practitioner. That is the fundamental basis. Under what provision of the Article 22? That is the base, Article 22(1). Sorry, I don't know. See, because Article 22(1), Article 22(2), that is with regard to the arrest, regular arrest in cases, 3 excludes that authority, and thereafter from 4 for the preventive detention, it has been, all the clauses have been given. This is the concentric circles, law and order, public order, security of state. Live link is also a very important aspect. from the date of detention, from the date of you and serving of the copies, and to the facts of the case, the live link plays an important role. Now, with regard to the sponsoring authorities, here I think you have sponsoring authorities. What are the facts you normally collect before passing the detention order? Sponsoring authorities, what is the expectation of these sponsoring authorities while preparing the grounds of detention, detention order and grounds of detention? You don't have any sponsoring authorities? SP might be the sponsoring authority, but at least the SHO of the concerned station who prepares and sends the request to the sponsoring authority, SHOs are there. What are the materials you normally collect? Which one? The mic out. You give, please. Hand over the
Lordship,
Yes.
repeated offender, that is habitual offender is one. We look into that aspect also.
Repeated offender, is it a requirement?
We have to see that the accused person has some background of this one,
Yes,
involvement.
he has a past history, no doubt about it. He has a
Past
past
history,
history.
yes.
Yes.
Lordship.
And thereafter, how you consolidate it? Then how you justify seeking foreign, sending it to the sponsoring authority, justifying that this person has to be detained. Because it's a preventive act. Preventive act, just like that, you cannot do it. You cannot just cut down a person's personal liberty just like that. That you have to substantiate. How you do it? What are the materials you normally collect?
Then second one is from the circumstances, is very likelihood of committing in similar crimes once released on bails.
Yes.
Lordship.
Likelihood of committing, because previously he has got that, he has come out on bail, so likelihood of coming out on bail. That likelihood, how you justify that likelihood?
He was already released arrested in other cases. After his release on bail, he committed similar crime again. So that is also one criteria we look into.
That will not be a criteria. Getting bail and coming from previous cases is not a criteria. From the case in which he has been detained, in all likelihood in this case, how he is going to come out?
The second thing is the network. Network cannot be established during the statutory period. The whole network, for instance, in PIT, in NDPS also, there is a big network comprising of financier, then the whole criminal syndicate.
Yes,
is there.
that will be a good point. See, the networking and finding out his link with others, and it is not a one-man thing, and it is a big group which has been doing it.
Yes, Lordship.
So,
That is also one
in that way, how you conclude, finally, how you conclude?
What we conclude is that once he is released on bail, he is very likely to influence the witnesses, then to tamper with other evidences and all. These are also some of the things we put up for detention.
Once the sponsoring authority sends the paper, the detaining authority, what you are expected to look into, what you call for? Any detaining authorities?
Sir, the measure,
Yes, please be seated, you can sit.
this one hindrance that we face, and the measure, this one's a tussle between the sponsoring authority and detaining authority is that, sir. The history sheet they are producing from the side of sponsoring authority, sir. It usually comprises of some hearsay evidence, not supported by any material fact. That is number one, sir.
No. Hearsay without any material facts, it cannot be justifiable for clamping your detention order.
And most of the time, when they sponsor for preventive detention, the person is already booked under certain, this one, special law, like UAPWA or NDPS Act. And they sometimes take it as a substitute for the special law, sir, the case under special law.
Yes.
That is the main thing that we are facing, sir. Another one is likelihood of being released on bail. Usme they just have the apprehension that the person is going to be released on bail. So, for example, in NDPS case, sir, for a case involving commercial quantity of drugs.
Yes,
sir,
section 37 is there.
that
Section
is not-
37 is there.
That is not exhausted properly, and they just apply for PIT NDPS. That's how, sir, before November 2000, somewhere around 2023, sir, 22, there was only 11 PIT NDPS case registered. And uske baad, from November to December, it suddenly rose to 110. Uske baad ek bhi nahi hua. Because we have issued one guidelines. As per that one, all the cases sponsored by the sponsoring authority has been returned back on the basis of that. Another one is the big question is about material facts suggesting connection with the network, what police is saying, sir. That is one thing.
Networking will be an important factor, no doubt about it. And in the networking, in your cases, you also collect the financial tracks.
Sir.
Financial tracking also you do it.
But that part it is lacking in the report, sir.
That is also important. Financial tracking is also an important factor. See, unless you paralyze them financially, unless you do that financially, you paralyze. And PIT NDPS is that one of the benefits is that you can bring the property for auction, you can also seal, everything is there. So apart from physical transportation and the other electronic communication and other way of communicating, that is one aspect of it. Financial trafficking, routing, financial movement of the amount and the financial trafficking also has to be followed it up. And in your, as a detaining authority, you are passing a detention order. What is the justification you give for fixing up the dates? That is within three months for getting the representation. You fix any time for the representation to be sent by the detainees?
Now we are not giving any that, sir.
Yes, after this, after the recent case.
Yes, sir.
Prior you have been giving.
Yes.
Now what you make in your order of giving representation? What timeline you give or what you say about?
No timeline.
Because
No
giving
timeline is
your
given.
representation, we can you must tell the detainee that he has got the right for making a representation.
Yes, sir.
What is that you say? You can make a representation for within?
Timeline नहीं दिया है, sir, इस बार.
You have timeline. Timeline you have taken. You can make representation. That's
Yes,
all.
Yes, that's all.
Yes, that is the right way of doing it. And with regard to cases of severe nature like UAPA and even in NDPS cases, you don't file the charge sheet within the stipulated period. But in both the acts, you have extended period of filing your charge sheet. UAPA you have 43D, and NDPS you also have one section is there where you can, that 180 days can be further increased. I think it's 37A, I think so. You have a period of extension. For extending the period of filing the charge sheet. That is there for filing of extended period of charge sheet is there. But what is the justification for whether you find out prior to filing of the charge sheet, detention order, whether the charge sheet has been filed or extended period of charge sheet is being sought for, permitted or sought for. Whether anybody of sponsoring authority as well as, detaining authority has requested the sponsoring authority with regard to this clarification. Now in your format, this has been added up.
These are the things we have in general make the mistakes, sir, because now as sir rightly pointed out, more and more cases are coming up, and couple of cases or more number of cases have been accused has been acquitted also. Many corrections measures have been taken, and SOP also has been given, sir. And especially UAPA cases, the provisions required within the Act to get the extension period within that Act rather than going to NSA. That aspect also has been started as one of the checklist has been added up to.
In NDPS also you have that provision.
Yes, sir. And
So unless you exhaust that, thereafter, because this cannot be an alternative. NSA cannot be an alternative for
yes, sir. Yes, sir.
the other aspects. That is important.
Sir, that aspect has been added up because previously the number of cases were not more, but over the period now the intensity and sensitivity is also more. It is, as rightly pointed out, it is a delicate issue to handle, and the sponsoring authority as well as the deputy commissioners or district magistrates have been sensitized, and that is also one of the objective of having this workshop also, sir. This common mistakes what we do and which can be avoided also, sir.
So detaining authorities, whether a murder case is an law and order issue or a public order. Sponsoring authorities. Sponsoring authorities. Grave offences, whether grave offences will be a law and order issue or a public order. Yes, sponsoring authorities.
So if the consequence of the murder involves the substantial number of
murders.
no, sir. Number of person in groups, sir, then it become a public order issue, sir. Law and order issue.
Yeah. Bottom line will be that offense, it might not be murder or anything, that offense but resonate into an public fear, public fear. Once it resonates to a public fear, thereafter it becomes a public order. It is not, the murder is not affecting that, it is not an isolated incident where it affects that person alone. That murder has resonated fear among the general public. That incident had resonated fear. That resonation of fear, that you have to build up the story. That is the right way of doing it. When you want to bring it out under public order, that you must have had some imagination to it, and thereafter you resonate, and for that you have to also have 2 or 3 witnesses' statement, that is all. Then you can bring it under public order. It is the gravity of the offense added to it, it must be shown that it resonated, it caused a fear phobia against others, general public, and thereafter it is required that it has to be done. And one suggestion I would say, since the Home Secretary is here, why you are not having a local law? See, even in Tamil Nadu we have Bootleggers Act, TN Bootleggers Act, Act 14. Even in Union Territory of Pondicherry, they have a preventive law. Why you are not having in Manipur a local law? I think that will give a lot of answers to your issues. Because though you have this NSA, whether you like it or not, you have to send a report to the central government. Unnecessarily you are making one more arm extended. And there again timeline is there. And there again you have to say, the state has to give a justification for continuing it. So one more thing is, it's only adding up to the work, adding up to your already, your works and other things. So if you have a local law like Act 14 for Tamil Nadu, or even Union Territory of Pondicherry has got, almost all states have. Manipur does not have. I would only say that if you have a local law, like detention law, preventive detention law for state of Manipur, then 50% of your issues can be resolved. And it will shorten, and the interacting officers, the final authority ends with here, with the secretary here. So that extended arm, the extended period, and the other things will not. See, one more officer, it goes ahead. Then subjective satisfaction, then again you have to look into it. Then there might be a reason for delay, there might be reason for some another mind coming into the act. So I would suggest that if it be more active, and once you bring it out under your state preventive detention, it is not necessary that it should be connected or it should go up to the public order. I'll share the Tamil Nadu's Act, wherein it says that bootlegger, prostitutes, drug offenders, all sand miners, illegal sand miners, so on and so forth. So those kind of offences which is particular to this state, you can add that and have a separate act, so that it will be easy for you to clamp this, because ultimately the result is 12 months you are going to keep inside. That is the ultimate idea. So that why you want to have resonate, bring it to a public order. For that you have to enlarge the scope. If you bring a state-specific detention order, I think that will solve a lot of your issues and problems. That you can deliberate on it. These are the grounds of judicial review, where these are to be avoided. Yes, this is what I said: law and order, outer circle; public order, inner circle; security of state. Yes. Affects only individuals or small group of even tempo community life is not disturbed. No public terror. So in this place only, if you bring it in the state-specific preventive law, then this kind of the outer circle can be brought in. It will be easy for you to clamp preventive orders. Live and proximate link. Detention order is only valid if there exists at the time of both passing and execution a live and proximate nexus between the alleged judicial activity and the detention. Link must be real, contemporaneous. Delay in executing the order. The unexplained gap. Though dates have been given, only thing is you have to justify by recording it and putting it in writing, have it in your file. Sushant Kumar Bainik case. Bainik case, it's an important case, wherein they would have explained about the live and proximate link. It again a PIT NDPS case. Here, already in custody, compelling necessity, why preventive detention is necessary despite existing custody under criminal law. A demonstrable likelihood that detainee will be released on bail. The grounds must address this specifically, not merely the asset possibility in general terms. Future threat. This is what you are mentioning about. Bail likelihood.
Yes, sir.
Yes. Bail likelihood, you should not, what the problem is, for bail likelihood, you place a similar case. Similar case, a 302 case means a 302 similar case. You cannot have a similar case because each case might differ. Likelihood of coming out on bail should be a co-accused in this case. In that case, if a co-accused comes out, then the likelihood of this man coming out is very much there. Similar case, another similar case, that facts will be different. That facts will be different. So that you cannot compare.
Here the two main issues is that the sponsoring authorities, they sponsor for preventive detention even before passing the bail order. That is number one. Another thing is,
But only thing is whether the bail order was, whether they filed a bail order or no bail order has been filed, that has to be clearly mentioned.
even before filing the bail objection, sir, they are sending the proposal. If we,
No, that cannot be done.
that is what we want
See,
to
what
get it
happens is,
clarified.
I'll say, the sponsoring authority, fearing of unable to file a charge sheet within the statutory period of 90 days to get over the statutory bail, accused get, they use this as an alternate. That is not proper. That you have to pull them and say that, see, you are got entitled to have the, see, you can object the bail, stating that investigation is in progress. When he will get the bail, only if within the statutory period, bail is not, he is unable to file the charge sheet. Charge sheet, non-filing of charge sheet might be for various reasons. Not in all cases, you can file it within 90 days. In such cases, at the last moment, you can file a detention order. At the initial stage itself, you file a detention order. Then it shows that you are only for an alternate purpose to keep him inside. For your thing, you are doing it and not for the real purpose. That is the way court will normally look at it. That is the reason once a sponsoring authority calls, sends a proposal, you have to call the IO and sponsoring authority, sit with him, find out the threadbare and do it. See, whatever may be there, as a district magistrate, I know that you have got too many works and you have to look into everything. But when it comes for the personal liberty, court does not look into whether you have gone for that or gone with this minister or that function or this function or some other. As regards the preventive detention, unless the district magistrate sits with the sponsoring authority, asks for the, or it cannot be possible for at all meetings, at least depute a person who has got that knowledge of it in your office and have the concerned officer to be called, get clarified. That I would suggest is that you have an exclusive team. Person who is well versed in the detention orders, passing of the detention orders, knows about the thing, and thereafter it should have a coordination with the sponsoring authority. Likewise, sponsoring authority, law and order officers also, they are also busy. But they have to have some specific time, come here, sit with the concerned officer, or both of them must have a good representative, a person who has got some knowledge of it, not a mechanical courier or a postman, just bringing and dropping it. Person who knows the facts of the case, brings it, sits, both deliberate, and thereafter you have to take it. That is the problem. Unless, because here the only ground what court says is non-application of mind. Non-application of mind, that is what they say. And that is the reason this coordination, you have to have an exclusive team. From secretariat, one person or two persons from secretariat. From the 2 or 3 SP office, one SP office, one person. So that concerned SP, that station out officer with the SP officer representative or SP will coordinate with the secretariat, detaining authority and the secretariat officer. So that coordination, a core team has to be formed so that it will be easy for interaction, clearing the doubts, creating documents or collecting the documents, everything can be done. The dedicated team, if you have, I think it can be done. And that from the dedicated team, one person must go to the court regularly. Because they must go to the court, find out the wavelength on what are the points which have been asked in the court, how they have been interpreted. You might do it in one sense, how they look at it. And that is, only thing is court might have a different view, but if you explain to them properly with the materials, then they might change. See, nobody wants a criminal or hardened criminal to go scot-free. Everybody are citizen. Everybody are worried about it. Only thing is whether he has been prosecuted or persecuted, whether it has been wantonly done. That is the only requirement court sees. So in that aspect, to clear that, this coordination must be there. As far as Madras High Court is there, I know one Balu was one person was there. He was the person who used to come from Secretariat regularly. Even as defense lawyers, we won't go and ask him, what is the point, any delay is there. For the delay all, we don't know, because it's an internal matter. We go ask him whether any delay is there on other things. But he was the eyes and ears of the detaining authority and the government to go and inform about what is the requirement of the court, how the court is asking, this case, this question is asking. Accordingly, they come up with a better version. That I think you have to have a dedicated team. Everything you have to only have a recording. This is pre-execution challenge. You have that Supreme Court, and what are the circumstances pre-execution you can challenge, and by way of HCP. There's Deepak Bajaj was the state of Maharashtra. And these are the decisions I've already given in PPT. You can collect it. And I've also given the citations. 12. This is just a run through about the comparative statement of both. The checklist. In what all we have just spoke.
Sir, another one is the language of communication, sir.
Which one?
Language of communication. Previous slide.
Which one? Grounds exist. First column. Yes, substantial grounds and satisfaction. Grounds exist at the time of order is made, cannot be construed post of subjective satisfaction of detaining authority is genuine and recorded on the face of the order. Grounds are germane to the correct legal threshold. If delegated or and usage, what do you want to say? Previous one.
Number 2, sir.
Point number 2, communication and process. Language, supply, legibility, representation, rights, advisory board. What is that?
Sir, this is another area where we are losing the case, sir.
See, that normally they take advantage, detainees take advantage of it, no doubt about it. Though they will say that language is not known. This language, then you have to have the entire translation of that. And supply and legibility, I don't think so you will have time, you will have difficulty, because that is prescribed in the act and you are going to supply it within the time frame. And legibility, after this modern computer, Xerox machine and computer printouts, I don't think so. Now we have difficulty in taking copies, legible copies. You have still have the problem of taking legible copies?
Only thing is the language, sir. If the person is illiterate, that way they are taking advantage of that.
That what you have to do is, if you are having such an idea, at the time of remand, we have to ensure that the magistrate writes that I have explained to him, he understood the grounds of arrest and his right of those things. If you ensure that the magistrate writes that, then you can always have a shield to say, even at the now for the purpose of preventive detention is making such a claim. See that at the time of remand, he said that he was explained, he understood, and thereafter he had signed about his remand. That will be the basic document. With that you can overcome. But that depends upon the IO's intelligence or the person who is taking him for remand to ensure that these things are recorded properly and get his signature. See, there if he signs and later he says, puts his thumb impression and says that I'm illiterate, you can compare and say, for the purpose of defense, he is doing that. That is the way you have to do it. You must be also little proactive in such cases. At the time of remand, you whatever you want, you can do it. Because these people, these accused, get intelligent only after they're going into the prison, getting used to with others, getting knowledge, talking with others and other things. At the first instance, you go, at the time of remand, you make these things, you make it given instructions to them, these things to be there in the remand order. That you make a request and ensure that that is being done. And magistrate writes and he signs that, then that's the end of it. Like first posting, once you are given first posting, wherever you are posted, you will go. Once you are thereafter give a transfer, you will start giving explanation, family, other things, difficulty, studies. So the first time will be the remand time. At that time, whatever is needed, you can load it. But otherwise, in prevention, you must also have a link with your prison authorities, jail superintendent, in serving the copies, getting it signed immediately, not the person who's, because normally the constable or the head constable SI goes, suppose superintendent says, tomorrow you come, you are busy today, they leave the book and come back. No. That you have to have a coordination with the jail authorities, ensure that the detainee is available, go there, get it signed on that day in front of the concerned police officer goes, does everything, signs, get the sealed everything and come back. That also you have to ensure. Because it's a team effort. But ultimately the detaining authority will be bombarded. But it's a team effort right from the SHO to the sponsoring authority, thereafter to the detaining authority, thereafter to the prison superintendent. So everything is a team effort. This coordination has to be there. I'll run through because I'm eating your lunchtime. Yes, whatever we have seen all these things. I could understand your anxiety. In school days we used to do, no? When a lecturer is boring, we'll clap hard. Any doubt, anything? Which one? Okay, thank you. And with regard to questionnaire, you want the questionnaire to be played? I was also asked, questionnaires have had the answers. You have given some 42 questions. You want it now or you want it after lunch? Yes, I've given the answers to the questionnaires that can be displayed in your screen. I'll start with the questionnaires and that is not an issue. Yes. Yes. That will do.
Thank you, Lordship, for your engaging and resonating discourse on the subject. Procedures and safeguards under Preventive Detention Law, including NSA, prevention of illicit traffic in NDPS. Thank you once again, Lordship. And now we have the lunch break. So all the participants, make sure that to be back at here 3:20. Thank you, everyone. Good afternoon, everyone. I hope everyone had a wonderful lunch. Now our Lordship will resume the previous session. So I humbly request Lordship to come on the stage. Thank you, Lordship.
Yes, good afternoon to all. Now I'm not going to again bore you. Only thing is with regard to that question and answer sessions. It's not working? It has come. I received around 42 questions from you. Collection of procedure and safeguards under preventive law. Collection of antecedent dossier preparations causes delay. One of the questions, but that is a requirement. We cannot say it cannot be a reason for delay, because once you apprehend a person, you arrest a person, you know you have been arrested, you know, and it is not a first timer you are going to put the preventive detention. Only a person, a known criminal, you are going to invoke preventive detention. And once a known person, you have every police station, every station has a history sheeter, every police station has a record. Apart from it, I don't know, you have Crime Record Bureau here. Crime Record Bureau has got the details of the offenders, regular offenders, known offenders, history sheeters. So the collection of dossier preparation causes delay. I don't think so. It be a proper reasoning, because you always have a history sheeters and files of the offenders. And for when, like I said prior to lunch, that you have a special unit for all these works, not to the regular police who have got the other works. Have one person dedicated for this. It is not the number of cases that is important, it is how you ground your grounds of detention. See, courts are only insisting on contemporaneous material, intelligence inputs, recent surveillance, recent criminal acts or speeches. Stale by advisory boards often struggle to produce fresh material. This is the question. See, second one, unlike regular criminal cases, preventive detention requires subjective satisfaction based on credible materials. IOs struggle to collect specific, recent and verifiable incidents within the short timeline. The same answer for what I said earlier, because you collect it, you already have it, but only thing is you collect and collate, that is all. Request for resource person to clarify recent amendments in CRPC and regarding trial procedure. I think the previous speakers would have dealt with this subject, but what I could say is, after BNSS, now electronic mode, digital evidence plays an important role, and all the investigating officers are now permitted to record search, seizure, statements using your phone. There is a separate provision has been given, and separate software has been installed in all the phones, and those things can be recorded, and which is also gives a timeline so that the authenticity of recording is there. And that is one on the investigation part of it. And second is, the same can be sent to the court, it can be filed, and it can be used during the trial. And only thing is 65B certificate is required. That certificate has to be given. And otherwise, the electronic form of, by using electronic form, you can do all the investigation, major part of the investigation can be done. And apart from it, you are now more duty bound. Now you have been given the timeline for completing the investigation, and courts are given timeline to complete the trial. It will take some time to synchronize with the present trend because already old cases are there, but still we have to follow that. And the one important aspect, as far as investigation is concerned, one important aspect is prior there was only police custody was only for the first 15 days of remand, and now it is within that 60 days, either it is going to offense of 60 days charge sheet or 90 days charge sheet, but till the 60 days, any of the 60 days, between that 60 days, any of the time you can take for police custody. That benefit has been given. So that is one thing of it. And now for the court, you are now given, I don't know whether you have adopted e-filing. E-filing has been adopted here. Charge sheets. If e-filing is adopted, charge sheet has been there, then there is no requirement for return of charge sheet. There is no question of return of charge sheet. Only if there is going to be any deficiency in the charge sheet, memo only has to be given. So e-filing, uploading of charge sheet has become easy, and thereafter it is a duty of the court to number the charge sheet, take it cognizance and number it. And there again, court has also now given a timeline that from the date of receipt of the charge sheet within this period, appearance of the accused, furnishing of the copies, you have to have the discharge petition to be decided within such certain period, and thereafter no discharge petition will be entertained. Previously, if there are 10 accused, alternatively one after another will file a discharge petition, protract the trial, not allow the case to be, trial to commence, cognizance to be taken. So that difficulty has gone. So that is one part of it. So these are the benefits of, and now examining the witnesses using audio video facility, virtual point, that is also there. And video conferencing facility is there, virtual witness is there, and safety of witness is also safeguarded. So these things and all are now the benefit of the new BNSS. So BNSS, by adopting to electronic evidence, these facilities have been given. So make use of it, more particularly in case of Manipur, where it's a hilly terrain and it's in each location is far off places where these electronic evidence can be put to use in a proper form for effective and speedy trial as well as investigation. So make use of the BNSS is now that benefit is there. And apart from it, electronic evidence, only thing is this timeline has to be there, and the seizure or recording with any electronic gadgets, if you seize something, you have to seize it with metadata. That is an important factor because metadata only will give you the actual files which is available in the seized material. So there is no tampering of it. So whenever a seizure is being done, do it with a metadata facility. Recordings. Yes, what I said for seizure, expert visit the scene of crime, collect evidence, timeline, police custody, clarification of documentation prepared for proposals under NSA in district level, dossier and narrative check, detailed history sheet and profile with recent photographs, drafted grounds of detention, specific facts and immediate causes, written justification for any delay between the latest offense and the proposal. Only thing is you have to record everything. Primary evidence and seizure of documents, certificate copies of the primary FIR and all previous history FIRs, search authorization letters, seizure list, go down Malkana deposits, entries, forensic chemical laboratory reports, and official forwarding letters. Likewise, when it's case of seizure of NDPS drugs offences, the seizure and recording of it must be properly documented, and the chain of link of custody must be proved. And that is the important factor as in NDPS Act, the main things what you have to look into is whether it is 42 or 43, chance recovery or recovery on information, prior information. So these things, once it's on a prior information, whether it has been sent, submitted to the superior officer, permission obtained, thereafter going to the scene of occurrence, thereafter along with them asking for a section 50, compliance of section 50, thereafter section 52A. 52A, it is now, Supreme Court is very clear that the samples have to be taken only in presence of a magistrate. And that gives you two advantages. One is taking of sample, it has been documented, there is no question of any doubt about it. Custody of the document is also, custody of the contraband is also now recorded, and thereafter it is easy for you for the destruction purpose also. Not holding it in whether in the police station it has to be held or in the court it has to be kept, whether chances of pilferage, everything is there. Those all goes off. Straight away you can go for destruction. So, on the NDPS case, these are the things we have to look into it. And 52A and thereafter 57. These are the major sections which we have to consider. And these sections, whether they are supported with the statement of witnesses, that is the evidence, and thereafter go. So, NDPS Act cases, collection of samples and everything has to be properly documented. Arrest memo, medical examination, remand applications, court remand orders, bail applications. These are the, to find out the history of the person to whom sponsoring authority against the detainees to be clamped with detention order. These are normally the documents which have to be collected. Likewise, now call detail records, digital forensic analysis, financial, this is what I used to say, call detail records and financial investigation records. So police has to do multitask work. You have to be a technocrat with regard to having the, analyzing the CDRs or electronic evidence. And for financial investigation, at least you have to have some accountancy or knowledge of routing for finding out the routing of the money. And likewise, travel documents, passport details, post-approval requirement, full set of relied upon documents, numbered and indexed, translated copies of all documents in a language the detainee understands. What are the essential, that is again same as question number 4. What are the most common procedure lapses that result in detention orders being quashed by courts? That is malafide, non-application of mind, irrelevant or vague grounds, failure to consider vital materials, procedural non-compliances. Apart from it, it will be delay, it will be non-furnishing of requested documents. 7th question, what important judicial principles should police officer keep in mind while proposing preventive detention? Detention to pass the test of dual constitutionality, Article 21 and 22, live and proximate link, public order, communication of grounds, right to represent. How can officers be trained to maintain stronger documentation, legal compliance? You have to have a checklist, develop standardized checklist covering each statutory requirements like dates, signatories, mandatory clauses, mock exercise, run simulated detention order preparations during training to catch common errors, legal advisory review, document templates. You can have a templates, it will be easy. Timetable monitoring, use case diaries or digital trackers, periodic audits and feedback. When it has come for timetable monitoring, I would, share a point where one now is I think IG. In our state, we had one Asra Garg IG. He is now intelligence IG there. When he was IG Southern Zone, where the lot of murder cases, communal murders, Madurai and beyond Madurai up to Kanyakumari, he was IG Southern region, where a lot of murder cases, hired murders, communal murders, ganja, rampant ganja, usuries like finance disputes, everything he used to do. When he came there as IG, what he did is, because filing of cases, statutory bails, a lot of people were going out on bail. What he did is, he prepared a model, and that model was that he created a model with all the investigative IOs of the respective stations, in which the concerned DSP, SP, all are in the part of this software. What they do is, he gave a tabulation, date of arrest, remand, whether come out on bail, stage of investigation, and days. Once, then he gave coloring of the boxes. Green will be, suppose if it's going to be 60 days charge sheet filed case. Green, it will be in green, then it will be in, green will show 45 days. Then orange will show 55 days. And thereafter, red will show 60 days. So these investigating officers must post the stage of investigation in that. When it comes to green itself, he will start calling the concerned officer. First he'll call the superintendent, DSP, what is the stage? It has come to the level of orange. What is the step? What is the stage of investigation? Why you have not filed the charge sheet? He'll start pulling. Then when it comes to, before 60th day it comes to red, he'll again call the investigating officer strongly. Then what they do is, immediately, once the top officer calls, investigating officer will ensure that charge sheet is filed within the statutory period. That is the way he avoided accused going out on bail on statutory bail. In fact, after Asra Garg had prepared, then it's sent to DGP. In state of Tamil Nadu, we follow, all the police officers follow the tabulation. Date of arrest, stage of investigation, when the 80th day, and automatically when it comes for 90 days, that popping up will come. So the officer will be alert, they will be called and questioned. I think that model you can follow, so it will be useful. What special safeguards and procedural requirements are to be observed in the detention matters linked to narcotic drugs? As far as PIT NDPS is concerned, because finance plays an important role in PIT NDPS cases, financial trial has to be done. Specific evidentiary requirements and grounds for detention under NSA in case of repeated extortion, kidnapping by undergrounds and PIT NDPS cases. Insurgents detention on bail usually relies on evidence of continued involvement in extremist activities. Grounds may cite recent attacks, repeated extortion, that's what we saw in the morning. Yes, this is again what we saw: sponsoring authority, vetting authority, government reporting, advisory board review. What are the essential components of a legally sustainable detention proposal? Full identification, chronological of facts, ground of detention, opinion note from detaining officer, legal basis cited, signature of every stage, relevant annexure list, a complete record file. What standards should be followed in preparing, verifying, completing, supporting documents and evidence for preventive detentions? verification of all documents should be attested, certified, so and so, language, chronology, completeness. What are the common procedure lapse result in detention order? Again, what we saw in, I think, section, question 4 or 5, we saw that. Again, it's again repetition. A lot of questions were repeated. Again and again, these things are repeated. How can you maintain accurate documentation, proper record management, legal compliance to withstand judicial scrutiny? What are the best practice among the police, prosecution, prison authorities, government are implementing? Yes, what I said, joint briefing, hold meeting among police investigation, public prosecutor, prison officials at earlier stage, license officers to be appointed, standard operating procedure to be implemented, training workshop, what lessons can be drawn, strict avoid using preventive as a substitute for criminal trials, maintain a legally sound and unbroken live link, ensure strict and meticulous procedural compliance, copies vernacular, prevent non-application of mind, facing all material facts. Violent activities for drug pinguins operating across Myanmar border. What is the judicially accepted standard? Courts have held that proof of an overtaxed recent offence is not always required. What matters is reasonably belief of likely future mischief. For example, in a recent case involving a drug trafficker, the order noted the detainee's continued propensity to engage in illicit trade and grave effect on public health and national economy. This reflects the detention can rest on patterns and intentions. Thus, standard evidence of continuing pattern or appreciable threat if an insurgent on bail keeps inciting violence. Propensity is important. Time limit for passing orders, representation against detention, advisory board proceedings. See, here one question has been there. PIT NDPS versus NDPS Act. Concurrent operation often invoke both NDPS Act for prosecution and PIT NDPS for preventive against the same accused for same incident. Is this permissible in law, or does it violate the principle against double jeopardy or Supreme Court ruling? Article 22 says that no person can be punished twice for the same offence. Here PIT NDPS and NDPS are not the same offence, and PIT NDPS is one is preventive, another one is punitive, that is after the conviction. So that principle will not, 22 will not apply with regard to preventive detention. So there is no doubt about it. Need for freshman accused already in judicial custody and NDPS country. The detaining authority must be fully aware that the proposed detainee is already in judicial custody. Likelihood of there must be compelling reasons and cogent material on record indicating a real and imminent possibility that the accused will be released on near future. Necessity of prevention. There must be to show that once released, individuals highly to resume their procedures, making preventive detention absolutely necessary. Review detention by government requires no under preventive on the advisory as confirmed detention. Yes, no record periodic review. Release on bail during preventive, unlike regular. Government has power under section 13, and if they reject, again they come as writ of mandamus. Please explain the examples for reduction under economic sabotage and national black marketing hoardings, artificial scarcity of essential commodity, large scale adulteration of essential truths, targeted. What is the process for lodging NSA outside the state of Manipur, like in Tihar jail? Section 5 permits the same. What are the common procedures that resulted in detention order being quashed by courts? Again, earlier we have seen that. What are the essential components of legally sustainable different proposals? Again, we have already seen this question. How can investigating officer maintain accurate documentation? Yes, again we have seen this. What are the mandatory sponsored detention proposal? Yes, these are all our question repeated. Again, answers have also been repeated. What are the latest principles governing preventive detention? Yes, we have seen this. Yes, this also we earlier seen. Securing attendance witness. Yes, this is what we are speaking. Challenges in securing attendance of witness from remotely. Early engagement, contact distance witness immediately after an incident, schedule their presence for trial. For detention, take statements, liaison with local police, assign investigator, coordinate with remote district authorities for witness travel allowance. Use check if distance or extreme, utilize telephone or video deposition where legally permitted. Plan for monsoons, anticipate by giving into bad weather. Best practice for improving conviction rate in serious offences. Specialized NDPS courts, dedicated prosecutors, forensic lab, witness protection scheme. Periodic review of pending cases for fast tracking. Ensuring all NDPS cases of high quality. Chain of custody records, avoiding legal technicalities. Training field officers, yes, follow the guidelines. This I think they would have taken, referred with this case, INRI to issue guidelines. Siddharth Rutra was the amicus curiae in that case, wherein he had made certain suggestions about framing of criminal rules of practice for the courts and also each high courts, and with regard to having the pre-trial, what are the things to be followed, pre-trial, how after the charge is framed, pre-trial date fixing, drawing a schedule, and thereafter proceeding with the case. That is there. Measures to reduce investigation while maintaining quality. Yes, allocate sufficient manpower for major cases, employ technology, digital case profile, database, prioritize serious cases and clearance agents, adopt team approach, divide tasks among officers, others on paperwork. Also, ensure court mandated investigation timeline followed to keep pressure on cook, regular supervision, senior officers, ensures investigation to solve. Yes, that is all. These are the questions which came to me. These are the answers. Hope all the answers are answered. Any other question? Yes? Mike? Behind the camera. Somebody was raising their hand. Yes, no questions? Then I take it that everybody has understood. Thank you.
Thank you, Lordship, for your amazing Q&A session. And for the last session, especially for Module 4, we have an expertise for this session. Honorable Lordship, Justice M. Nirmal Kumar, Judge Madras High Court. Lordship will be delivering on the topic, and it was already shared by the previous resource person also. And procedures and safeguards under Preventive Detention Law, including NSA, prevention of illicit traffic in NDPS. So may I request Honorable Lordship, sorry. For this session, we have an expertise, the Honorable Mr. Justice Asim Kumar Roy, the former Judge, Calcutta High Court. So may I request Honorable. Thank you, Lordship. So may I request Honorable Lordship, Mr. Justice Asim Kumar Roy, former Judge, Calcutta High Court, for this last technical session. So may I request Lordship to deliver the gatherings. Thank you, Lordship.
Very good afternoon. I am last part of the lecture deliberation of Justice, my brother Justice. I was present, and I find that you have sent some questionnaires to was distributed, that he has replied and explained each and every question wise. So, and when he asked all of you to whether you have any queries, none of you have responded, but my Lord was saying that means that you have understood what my Lord was trying to convince you. Now, in my turn, what I will say, let me start. One minute. Yes. Before I start with, I must tell you that take you to the provisions. As you know, that by now you are already aware that the prevented in our constitution, if you see that it is in part 3, this is the part 3 is the fundamental duty, this is the fundamental rights of a citizen. And this is the chapter, part 3, which considering the Article 21 of the Constitution, where it is said that no person can be deprived of his life and liberty except according to the procedure of law. Now, if you see the provisions of Article 22 of the Constitution, we will find that first 1 and 2 is the thing that where a citizen has the every right that immediately after arrest within 24 hours he has to be taken to the nearest magistrate, and he has to given the grounds why he have been detained, that grounds should be communicated to him. And unless the court confirm his detention, that detention would be illegal. Nobody can be kept in detention without the order of the court. And next is this, that help from the legal practitioners, that he can have the advice or legal advice from a lawyer of his own choice. The next part is, but while we are coming to the Article 3, we find that above two rights have been taken away by the framer of the Constitution. Although this is the part, this part is dealt with the personal liberty, life and liberty, but in this part only that has been taken away. This is a very interesting thing. So why? Because to secure the interest of the state, secure state safety and security, these are the main object. That is the provisions of preventive detention has been introduced. Right. Now what I say that the two things are there, there are other provisions where that similar preventive detention provisions are there, like UPA and other acts, TADA and this thing. But we are presently concerned with the NDPS and the National Security Act. The first is this, to prevent from engaging in illicit traffic in NDPS. That is, and if you, that the maximum period is there, the 3 months, but not exceeding 6 months. But it is when 3 months is a constitutional statutory bar, that it cannot be extended without the advice of the advisory board, with the approval of the. But in this case, why 3 months? This is because if it is found that they have described a place called vulnerable area. What is vulnerable area? That you have to find from the, if it is this trafficking is going inside or through or in and around the vulnerable area, then the detaining authority has right to, without the permission seeking the approval of the advisory board, to keep the person in under detention for more than 3 months. And then next is the National Security Act. What I am saying that you have already noticed possibly that in the NDPS Act, detention is permissible up to 2 years, but in specific circumstances. But so far as the National Security Act is concerned, it must be confined to only 1 year. Now, you have already been taken through the various things, but let me start. I will summarize what I have been told, that I am going to summarize these things. That what are the technical errors in passing the order of detention, what one should do and one should avoid, how the law to be applied. These are the things and how the process of it. There was a case where, what happened, it was a case of Bengal where a person was detained under the Prevention of Detention Act. What was the case against him? As it appears from the detention order, that there was only one single and solitary act of that time when this incident happened. In Bengal, there was going on this kind of operations, is wagon breaking. The railway wagon, they broke and take out these articles from inside. So that was the incident where a district magistrate issued an order of detention. What is that? This was on only one single and solitary act of wagon breaking has been referred, that due to this you have been detained. Then before the court, the question arose that was he involved in only one single incident? In response to that, a counter affidavit was filed from the side of the detaining authority. And in that counter affidavit, they said, no, not this single incident. There are several incidents, at least 9-10 incidents, in which he is regularly doing all this kind of wagon breaking, threatening the local people and also extorting money from the innocent persons. But those were not the part of the detention order. Then when the matter reached up to the Supreme Court said that from the counter affidavit it is found that apart from those referred in the detention order, you have relied on some other incident which you have not communicated. That was the part of your subjective satisfaction, but that thing you have not communicated to the detainee. Therefore, this is an illegal order. It cannot be valid, because it is your bounden duty to communicate the detainee all the materials on which you have drawn the satisfaction. But here in this case, you have relied on only one single satisfaction you have noted in the detention order, and you have communicated it to the detainee. But while you filing the counter affidavit in the court, you said that apart from that you have other many things, you have circumstances available with you, and on that basis you have done this. So therefore, what is the outcome of it? That by this you have denied the valuable right of the detainee who has been detained under preventive detention, without any trial or conviction, that you have been deprived him from properly and effectively and meaningfully deal with the detention order. So now I understand that therefore you should be very careful while passing the detention order, that the person who is going to issue the detention order, he must be careful and be alert to record all from the materials wherefrom he is drawing satisfaction. And when the case it may come to the court, you should be also very much more alert in not including any facts, those who are not the part of the communication to the detinue. I think that you have understood the proposition. Next one, there was another case. It was a case where the petitioner, the detainee was arrested and then he was discharged from the case. So, but it was the case of the detaining authority, whether he was discharged or not, that is absolutely irrelevant and of no significance. Right? So, but in the detention order, that part that he has been discharged from the case finally, and it is not one of the such case where he has been not been able to be convicted because the witness turned hostile or the witness had not come forward to depose against him. But this is a case where this police authority was unable to collect evidence to sustain the charge against him. Therefore, when you have to, this discharge part is to be part of the detaining of the materials from out of which detaining authority is drawing the satisfaction. Here I must say that the thing from which detaining authority drawing the satisfaction, this not is subject to the judicial review. The court will not reappreciate whether your conclusion was correctly done or not, but court will ascertain whether that your decision is supported by any materials or not. So kindly remember that when the detention order is passed, that there may be some materials which may not act to you be very relevant, but it is, if you found that this can provide a defense to the detainee, that you have to take into consideration. You have to, this is your capacity and quality, how to deal with that part of. So therefore, that part you have to be careful about that this is the case. Here the detention order was quashed because of this thing, these lacunas. It is said that the failure of the district magistrate who passed the order of detention to swear in affidavit will indicate that there was no other material before him. In such circumstances, the order of detention will deem to have been passed mechanically and would be colorable exercise of the power. And other case I said, in the counter affidavit, this detaining authority in their affidavit has said that apart from that single incident of wagon breaking, there are several other cases and those taken into consideration while passing the detention order. But there is no reflection in the detention order or from the materials made available to the detainee. And the one question I find that you said that the question was that somebody has been detained under preventive detention at Manipur. But for the reason of safety and security, you are wanting to detain him in a jail, maybe at Calcutta or at Tihar jail at Bengal, Delhi, or your the jail in Pune. But the question is whether you can do it. That is one of your queries. Here I will request you to take you to the provisions of section 3. That there it is said that this book is alive. Just give me the preventive detention. NDPS. 1 minute. Don't have. Okay, 1 minute. Just read it. Today, every paper has been confused. I was told to come late and then. Let me go to the table, okay? Because today my papers are very haphazard. Okay, and you bring on the speaker, mic. Here the question arose that, as I was telling you, that the question was that, as I said, that the person has detained at in the state of Manipur. Okay, it is audible. I am audible. Okay. So, but for the reason of security and safety, the administration decided that whether he should be removed, it would be better to be removed at Bengal or at Tihar jail at Delhi. So, whether it is permissible or in law or not, this question came up for consideration before the Honorable Supreme Court. The Supreme Court said the place of detention is a matter of the administrative part, administrative policy, choice. So, therefore, where he will be detained, that part can easily, there he can be detained, the detainee can be detained anywhere, either in the state of Manipur or anywhere outside. So, there is no legal bar in doing that. But only question court will see that behind such removal, whether there is any malafide or not. That is the only thing to be decided. In one case, this is a case at Jammu and Kashmir. What happened? Here, this is to be very careful that sponsoring authority has said something in the document they communicated to the detaining authority. And detaining authority, what they did? They only copy and paste it. So, Supreme Court highly criticized this action and said this cannot be done. You cannot be act as a rubber stamp of the sponsoring authority. You have to independently come to your satisfaction, draw your satisfaction to say why, on what basis you are coming to the conclusion that for the safety and security of the state and other things, those who are referred in the provisions, that his detention or is necessary in the custody under the preventive detention. Here also, what was the case? Here the DFO was the sponsoring authority. So Director Forest Officer, District Forest Officer, who alleged that detainee is a habitual land grabbers and engage in of encroachment of forest land and allied activities. Illegal mining, smuggling of forest resources, stole out the plots of residential to the from the out of the forest land. The order of, but on the same set of facts, what the detaining authority did, they issued two different detention orders. This is not legally permissible because invoking two different provisions of the detention order, this order, you cannot issue two separate detention orders. Because facts is one, single one, so one and solitary one. And one of the important thing is this, that detention order always to be used in the issued in the language of the detainee. That materials to be supplied to him in the language of the detainee so that he is capable to understand what is the case against him. Next is the relied upon copies. This is very frequently done. The copies which have been relied upon are not supplied to the detainee. Another thing is this, that the copies you have supplied, but that is illegible and cannot be read, and it not legible and cannot be read and understood what is there. And copy should be very fresh one. And as you know, that the non-supply of the material facts, this is one of the recent case where what happened, that from the order material supplied and from this discussion of the detaining officer, it is found the detaining authority has very much relied on the evidence statement of a particular person. But surprisingly, that copy was not the part of the detention order. So, when this is a very important link in which moved you to pass the detention order, when that is not supplied, this is one of the serious irregularity and he said lapse or lacunas in the detention order. Therefore, this order was not sustained and was quashed. So it should be very careful to supply if you refer anything. But it is not that only something you have referred not relied upon, but made some passing comments, or just referred something, may take some reference. Just not the exact casual reference, what I say exactly, that casual reference of anything, that you need not have to supply. But if you have to rely, after taking the reference out of that, and then you relied on it and acted on thereupon, then it is your bounden duty to supply the copy to share the copy with the detainee. Another thing is composite ground. That is very important, that very occasionally I found that mistakes have been committed by the detaining authority. What is composite ground? Now the law is this: if a detained person is detained on 4 grounds, if 3 grounds are failed, finally could not succeed, that 1 ground should remain, and on that basis detention order could be upheld. But in one case it is found that in 4 paragraphs, 4 different incidents and lucidly narrated, and it is said that might be it appears that on the basis of which the detaining authority took the decision. But it is finally found there was a 5th one, and on that basis, 5th one, on that basis the order of detention was passed. The court found maybe that all the 4 previously on which no decision has been taken may be valid one, but you have taken a decision on the basis of an invalid one, that is a 5th one. But so far as the other 4 stories are concerned, you have not acted thereupon. So, in this case, you cannot, this is a composite detention order, because you have not taken, it is not a separate ground, there is one single ground. And since the 5th ground has been failed, that all the 4 grounds will go. So, the detaining authority should be very careful. Once again I am repeating, the detaining authority must make his independent satisfaction. The sponsoring authority may send you certain facts and their satisfaction, proposing that he should be detained for this purpose and this, that. But the detaining authority will not act upon, not just work on it as a rubber stamp, put a rubber stamp and forward it. They have to independently decide on it and then pass the detention order. In another case, what happened? That detainee was detained in a jail. That was the date, 27th of September 2023. He made the representation. But detaining authority very callously did not forwarded it in the proper way to the central government or to the advisory board. So, thereafter, the order of detention was challenged in the court of law. In the court of law, it is found that detaining authority filed their counter affidavit, and they said that this was not our fault, that the jailer or superintendent of jail sent under ordinary post, and it has not reached to us, and we also could not able to track it out. So immediately after knowing from his application that this has happened, we collected the copy of the representation from the jail authority. Now we have considered both the authority, detaining authority, and central government, and we have approved the order of detention. Supreme Court said no, because you see that why there is that, as I mentioned, told you, that the actual representation was made on 27th of February 2023. But when the matter came up before the court, they all of a sudden, the detaining authority become alert or conscious and then what they did, they served take out the representation and send it to the 2 authority when it was One is on 11th of June 2024, nearly a month, year after, and another on 12th of June 2024. And thereafter, within 2 days, both the authorities considered and rejected the representation. Supreme Court said no. There is a delay for nearly about 9 months. So this cannot be done because you are without trial, without any basis of evidence, you have taken steps in detaining the person concerned. Therefore, this delay is a very serious lapses on your part and it is violative of the constitutional safeguard. Therefore, this order cannot be sustained and order was quashed. So, not only that, you have issued a detention order and person is detained in the jail, you have to track and monitor whether he has submitted the representation. First of all, that there should be no delay in serving the grounds of detention with all the copies, all are legible and the readable, and that all the required upon documents has been furnished to him. It has also to be careful that his representation has been reached to the statutory authorities or not. That is very important. So therefore, the sponsoring authority should take care of it, that whether from jail that has been sent to the appropriate authorities or not. Otherwise, this order on the ground of delay, this order of detention will go. And another important thing is this, not only that the detainee should be given the earliest opportunity with all the materials to to submit his representation. At the same time, the other authorities that before whom this representation has been made, they has to, this is their obligation to dispose, consider and dispose of this representation in accordance with law and with an independent finding, so immediately thereafter, within a short time. Otherwise, detention order will go. Case, this relates to Telangana case. In the Telangana, there is a act is prevailing, that is Telangana Prevention of Dangerous Activities Act 1986. By virtue of this act, the state of Telangana has the power, this is the state law, to pass an order of detention. In this case, that I think that I have been shared with one what you want to know. Here, lucidly they have stated many things. It is said that wherever the first is that detaining authority should take into consideration only relevant and vital materials to arrive at the requisite subjective satisfaction. Just remember, you must know that what is the difference between the subjective satisfaction and objective satisfaction. According to me, that this is a pure water. This is my subjective satisfaction. But when I am to reach to an objective satisfaction, I have to go through it and find how the pure the water is. This is the materials from otherwise. But here in this case, for passing detention order, only subjective satisfaction is necessary, not the objective satisfaction. So there it is said that only relevant and vital materials to be taken into consideration, not the irrelevant materials. Next is this, that the interested, the subject is, there is an implicit duty to apply his mind to the pertinent and proximate matter and to avoid those which are irrelevant and remote. Suppose you are issuing, just now it was said by my lord earlier in the earlier deliberation, that you have to see that proximate relation between the incident and order of issuance of the detention order. Maybe that a person was arrested in connection with an offense about 8 months back, and within few days he have been released on bail. Now he is once again indulging with similar activities. But what you did, you referring the first incident that where he was arrested and detained in the jail, you issued the detention order. this has said considered to be a no proximate connection with the detention order. These facts which led you to issue the detention order and the date when you issued the detention order, those have no proximate connection. Therefore, in this case, if a person getting out of bail and then he committed and indulging in other offenses, then it would be your duty and it would be your prudent to rely on those incidents. You can refer the earlier incident that there was an incident in which this has happened, but he applied to the court for bail, and after considering the length of detention, he was released on bail. After coming out, he has committed 3 offenses. And unless he is detained under the preventive detention, this cannot be stopped. It cannot be stopped. He cannot be prevented. Therefore, you issue the detention order. But only on the basis of the first detention, of a crime or FIR, if you pass the order of detention, it may not be valid one. And as I said earlier, that while the court is sitting over the order of detention in judicial review, the court will not see whether the satisfaction, the result of satisfaction will not reappreciate the satisfaction. That it may be 2 views are possible. The detaining authority took one view out of that, and the court is taking another, there is another view is possible view. But since there is an available possible view, court will not interfere with the detention order. What the court will see that how you have acted, the detaining authority, how they have acted. Whether they have issued the detention order by considering taking into account irrelevant and the irrelevant materials and acted and was influenced by, and this was a case of non-application on mind and influenced by other unwanted materials. Then in that case, the order of detention will be interfered. And whatever on the basis of which the detaining authority passed the detention order, the detaining authority must be careful that there must be a reflection of their entire subjective satisfaction, on what basis and how they have drawn this subjective satisfaction, that must be reflected in the order of detention. Here, in one case, it is only said that it was necessary to prevent the detainee from acting in a manner prejudicial to the maintenance of the public order, and nothing else. So, court said, no, this cannot be. From this, it cannot be inferred on what basis you have come to the conclusion. You have to, it is your duty to reflect the materials on the basis of which you come to the conclusion. Otherwise, the detention order cannot be sustained. And another thing, sometimes it happens, and quite frequently it happens, that inability on the part of the police machineries to tackle the law and order situation should not be an excuse to invoke the jurisdiction of preventive detention. So therefore, the thing which can be managed through the regular law and order law, that Indian now it is the BNS. So for that, if that be offense, for suppose a person has committed a murder, you cannot issue a detention order. But if you found that person is a he is in the locality, he was doing various mischief. He was a extortionist. He is from different persons, he is extorting money. That there are regular cases complained against him. This is a good case for issuing the detention order, although you can charge him for extortion under the BNS. But where there is that single incident or 2 incidents that he has committed murder, that those are not the thing which you police can handle it with the regular law, which cannot be the subject of the preventive detention. In Telangana, there was two FIR was lodged against a person. And the allegation was that he has snatched chains from two women. On the basis of that, the order of detention was issued. The matter was challenged and came up before the court for consideration whether the detention order was appropriate or not. Supreme Court said this true incident of snatching could have been handled as an offense of robbery, or if not robbery, it is a theft or robbery, because not dacoity, because it is by a single man. So it can be dealt with in that way. But on that basis, you cannot issue a detention order on the two single incident. And in that case also, the detaining authority before them has no statement of the woman, or there is no statement of the local people that for this incident in the area, the people have been, the women flock have been very much terrorized. They are not coming out or not going to the market because of this thing. So this is not a fit case where the order of detention should be issued, and accordingly order of detention was set aside. But if you could have the case that that guy is regularly involved in snatching of the chains from the woman, and you have arrested him and he is getting bail within shortly, but it could not be prevented, and the whole locality has been terrorized due to that gentleman, that man who is committing the offense, that criminal. This is then only you can very much issue the order of detention on that basis. And the sponsoring authority, that is police, can approach the district magistrate or this authority who is empowered to issue the detention order for issuing that. But you have to be clear that what is the fault on the part of the investigation. They are not properly collecting the materials, and whatever they are done very hastily, maybe due to various reasons. But you have to first collect the materials so as to justify your action before a court of law. Because all your action is subject to judicial review. Not only the action of the police, every citizen of the country. So you must be very careful while doing that. I understand in this state, Manipur, there are several order of detention was issued. Kindly tell me who is here that how many order has been succeeded. Only, as I understand, 2 order. In one case I understand where the detention order was issued. Right. There, what the detaining authority did, they have issued the detention order on the basis of that some mistake was there. And therefore, the accused was on bail, but he was detained in the custody. So immediately when it was pointed out and this habeas corpus application was allowed, the concerned authority came back, and within few days they have issued a fresh detention order. But what was the fault? That after the previous detention order was quashed, he was not released from the jail. He was detained in jail for a week, and thereafter the fresh detention order was issued as if that this is the continuation of that detention order. That was very much bad, and accordingly, very rightly, the court set aside that order. And as I told you, that the one of the very important test is this: the nature of the allegation is such that the ordinary laws cannot deal with them or prevent subversive activities of the affecting society. This cannot be the ground that if these states is satisfied, then the detention order could not be prevailed. And as was what is the difference between the law and order and the public order? So detention order can be utilized or be invoked in case of this, not in law and order case, but where there is a case you have made out that is a, there is a, that on that there is that public order, that it is violating, this is interfering with the public order. Though if it is a law and order, it may affect a few individuals. But if it is this is a public order, that it has to be affect the public at large and the whole society. Throughout the area, you are terrorizing the people. Throughout the area, you are extorting money on different pleas. Or throughout the area, you are indulging or you exciting the people to revolt against the state. These are the things where it has largely affected the areas. It is a fit case where the detention order you will be issued. But it is a stray incident, one person was killed, a girl was raped. These are the cases where it can be dealt with by the ordinary law. Therefore, in those cases, the detention order is not actually to be invoked. This is a case, it is named as Amina Begum versus State of Telangana. The similar case that the state laws violation. A few years back in the year 2023, that bench was presided by the present Chief Justice Suryakant and sitting with Justice Dipankar Dotto. They have laid down the what should be the thing they have to be followed. Right? So, please come and read one after another. From 1, 2, 3, 4, 5 and up to 9. Just read slowly so that people they may understand.
Roman number 1. The order is based on the subjective satisfaction of the detaining authority in the absence of such satisfaction as to the existence of a matter of fact or law upon which validity of the exercise of the power is based would be invalid.
Yes.
2.
So you understand? Or what would be when the order will be invalid? When the detaining authority, out of the materials on which the detaining authority drawing the subjective satisfaction is no reflection in the order.
Yes.
Right? Come to the next.
In reaching such requisite subjective satisfaction, the detaining authority has to apply its mind to all relevant circumstances, and that not to be based on material extraneous to the scope and the purpose of the statute.
Right? So this is another important guidelines.
3. Power to be exercised to achieve the purpose for which it has been conferred, and if exercised for an improper purpose not authorized by the statute, is ultra vires. 4. The detaining authority has to be acted independently and not under the dictation of another body.
That is what I said. The detaining authority, the sponsoring authority ask that district magistrate, that police, that this or this against this person a detention order be passed under the National Security Act. But the detaining authority cannot say that merely just quoting that this is what they said. On that basis, if he issued the detention order, then it will be declared invalid. So what he has to do? He has to apply his mind on the basis of the materials brought to his notice that this is a fit case where the order of detention should be issued.
5.
Next.
The detaining authority, by reason of self-created rules of policy or in any other manner not authorized by the governing statute, make itself disabled from applying its mind to the facts of its individual case.
Next.
6. The satisfaction of the detaining authority must rest on materials which are of rationally probative rule, and they must give due regard to the matters as per the statutory mandate. 7. The satisfaction be arrived at bearing in mind existence of a live and proximate link between the
This is what I said, that there must be a proximate relation from the incident on the basis of which you are drawing your subjective satisfaction and when you are issuing the detention order. If it is an incident of year back, Now you are issuing the detention order, it will be declared, suddenly declared invalid. So therefore, if there should be any, that the regularity, continuity of the offense committed.
The past conduct of a person and the imperative need to detain him, or it is not based on material which is stale. 8. The grounds for reaching the requisite satisfaction are such which an individual with some degree of rationality and prudence would consider as connected
It is
With the-
very important, this point.
with the fact and relevant to the subject matter of the inquiry, and in respect of whereof the satisfaction is to be reached. 9. The grounds on which the order of preventive detention rests must not be vague, but are precise, pertinent, and relevant, which, with sufficient clarity, inform the detainee the satisfaction for the detention, giving him the opportunity to make a suitable representation.
This is the last one, no? Next
Last one.
Okay.
Yes.
It's over?
Yeah. This is the second last.
Oh, second last, okay.
The last one is the timelines as provided under the law have been strictly adhered to. Thank you. Lord. Added.
If necessary, I will share the copy of these guidelines to you. You circulate among the concerned authorities. And just I am in short I am referring some situations. This is regarding consideration of representation. So now, what I say, that what are the, as I am telling you, that how the detention order to be issued. As you know, that order of detention is not a punitive order. It is a preventive order. What is the difference between the preventive order and punitive order? Punitive order is such order where after trial and consideration of the evidence, the court come to a conclusion that man is guilty in committing the offense. But preventive detention, there is no question of trial. Even the right of the person concerned he has the right to be produced before the nearest magistrate within 24 hours of his arrest has been taken away. His right to have the grounds of arrest immediately after arrest and but before detention, that has been taken away. In case of detention, the ground of arrest need not have to serve upon him immediately. On the contrary, that can be timed within the statutory limit that have been prescribed either in NDPS Act or in the National Security Act. Third one, his right to consult a lawyer of his choice has also been taken away. Therefore, this is a preventive detention. Sometime in somewhere it is said that preventive detention is a jurisdiction of suspicion. That on the suspicion and jurisdiction of apprehension. Apprehension is that on apprehending that if he be remained in the out of the custody, he will indulge in various nefarious activities which will lead to that would be a threat to the interest of the state or the subject of the society. Therefore, it should be immediately stopped. So, very relevant things are this, that one of the thing is this consideration of representation. The board, the consideration by the board, this has been considered by the different authorities, but consideration by the board is independent of everything. Therefore, it has to be considered in separately and independent. Delay. There must not be any delay. The authority concerned, the sponsoring authority as well as the detaining authority must be very careful in that there has not been any delay in disposal of the representation. As regards the documents, all the documents relied upon by the detaining authority must be shared with the detainee, and the documents must be not only be legible but must be readable and in the language of the detainee. This is one thing. That one thing must be remembered by the sponsoring authority as well as the detaining authority, that in the detention order, mere narration of the facts on the basis of which you are thinking that is a fit case where detention order would be issued will not do. You have to record your satisfaction that on appraisal of these facts, I am of the opinion that this is a fit case where the person to be detained. 2-3 stray incident is not sufficient. As I referred to some incident in Bengal, that a person was detained on the allegation that he was involved in wagon breaking. Only one incident was referred. Subsequently, when it was challenged before the court of law, the state lawyers committed the mistake. In the counter affidavit, please wait some time. Shall I continue? No issue? So, that in the detention order, only one stray incident was referred, that this particular accused was involved in wagon breaking. But when this was challenged that on the basis of this one stray incident, which you can handle with the regular law, that time Indian Penal Code was prevailed, you could have charged him for theft and the dacoity or robbery, whatever may be, and other mischiefs. But instead of that, why you have issued the detention order? Then and there, what the state lawyer in his wiseness, what he said, in the detention order, they have recorded that not only, there are several incidents, there are at least 9 cases where he was found to be involved in wagon breaking. Immediately Supreme Court said that those were not the part of your subjective satisfaction. Therefore, now what you are saying, that while issuing the detention order, you have taken into consideration those facts, shows that you have acted arbitrarily and mechanically. Because in your order, there is no reflection of that part of the consideration. Also that those materials are not been shared with the detainee, so that he could have given an effective and that meaningful reply. So he has been deprived out of that. Therefore, the order of detention could not be sustained. So, I will request all the officers who are dealing with these matters that whenever any matter is challenged before the High Court, to not only to act on the advice of the lawyer, you should apprise the lawyer concerned what is the actual position. And be careful that what you have not taken into consideration while the sponsoring the sponsoring for the issuance of detention proposal, sponsoring the proposal for detention, those who have not taken into consideration, or the detaining authority has not taken into consideration while they are passing the detention order, must not be referred once again. Otherwise, detention order will be declared invalid. This detention order, it needs very scrupulous and meticulous training of the officers. There should be a very, you have to select some very important officers, those who have to deal with these areas. And also like DRI and customs, while the Cofe Posa was prevailed, DRI has a special cell who actually dealt with that. Because the ordinary police officer, those who are every day involved in the law and order problem, may not have such much of expertise to prepare a detention order. And when the detaining authority, the district magistrate or this collector or the central government or state government, they have dealing with this, then in that case also they should have the proper appropriate support staffs to support them in passing such order. This is very much essential. Otherwise, whatever I will say after you hear, or whatever the decision Supreme Court will give, they will not, nobody will consider that and pass order, and every order will someday, the bad day after, will be quashed. So one has to be very careful as to, you have to create a special cell to look after this. If in your state you require that for to maintain the public order, so that detention order is required to be passed. Another thing, the communication of ground, this is maybe repetitive in nature, I am repeating because these are very much important, that the grounds actually on which the detention authority is relying on, and the subjective satisfaction, the basic materials, on that basis that grounds have been taken, to be clearly communicated to the detainee. And in his language, the document should be readable, legible, and to each and every document should be supplied, those who have that have been relied upon, and that should be in the language of, suppose that is the, everything has been, statement has been recorded in English or in the some local language, but the person who has been detained, he has no knowledge about that language. So therefore it would be your duty to correctly and exactly translate that thing and then to supply him as the true copy of the statement, certifying that. I have summarized 24 points. What I find, these are very important points to be considered by the detaining authority. And what I propose, that it is in my language, so as to, for your better understanding, this should be in a more concise form. So, if not possible today, after going back to Calcutta, I will share with it with the Learned Advocate General of the state. So he will circulate it among the officers and the those persons who are the authorities concerned, who are actually involved in issuing the detention order. Now, I like to know, any one of you have any question regarding this? Please raise your hands and ask me the questions, so that I can clear if there is any confusion in your mind. The left hand side, I find the police officers are sitting. Any one of you have sponsored any case for issuance of the detention order? Please tell me who are out of you, who is that gentleman? Who is that police officer, who has any single officer as is there, who has sponsored any case for detention? Anyone was there, is there? Yes. Yes. Please first introduce yourself. Who are you?
Good afternoon, Lordship. My name is Sivakanta, SP Imphal West.
Okay. Yes, Mr. Sivakanta.
Yes, sir. Sir, we have sponsored some 8-9 detainees under NSA.
8-9 different cases?
Yes, sir. Yes, sir.
Okay. So, on what basis you have, those offense they have committed, what is the nature of the offense?
So, normally most of them are under UAPA cases, sir.
Oh.
UAPA cases. So,
UPA.
those who have been arrested number of times, 5-6 times, and who are involved in...
Still they are indulging the same kind
yes,
of
sir,
offenses?
Yes, sir. After
Achha. Tell me that length, the period in which these kind of offenses were committed.
Sir, it varies.
Spread within which period?
Spread within the period of about 2-3 years, sir.
2-3 years.
Yes, sir.
The last one,
The last incidents have happened, say 5-6 months before.
and when you sponsored the case for detention, immediately thereafter,
No, sir. After the persons are sent to judicial custody.
no,
So-
that's all,
Yes,
not
sir.
that.
Yes.
I am saying that on the third case,
Sir.
that FIR was lodged in last case.
Yes, sir.
So after lodgement of the FIR, the person was arrested within how many days? Shortly.
No, sir, in our case, we have already arrested the person, and after that, after sending to judicial custody, we.
There is
put
no
the
nothing
sponsor.
wrong.
Yes, sir.
While he is in detention in the judicial custody,
Yes, sir. That
there
time
is
only-
nothing wrong
Sir.
to sponsor his case for the
Sir.
this thing for issuance of the detention
so
order.
when the
Right.
bail moves,
So you have the two options left.
Yes, sir.
If the incident, say for the example, that the last incident you are now referring to has happened in the month of January,
Sir.
but the man was absconding, you could not be able to apprehend him.
Sir.
In the month of July, you have arrested him.
Yes, sir.
Now, you could have sponsored the case in the month of January or February to the detaining authority to issue the detention order. Because he is the regularly is a habitual offender, and he is committing the offense one after another, and every time after detention in the custody for some days, he is coming out and again repeating the offense. So this is a fit case where you issued the detention order.
Yes,
You
yes.
could have.
Yes.
But you have not, because he was not arrested, still he is absconding, but law permits to issue a detention order against a person who is absconding.
Sometimes, sir, the lordship, these individuals are not identified. We sometimes, because of our proximity with the border, sometimes this accused person, they fled from Manipur to
No.
Myanmar side. Sometimes then they come back, so we...
No, but unless you identify the person,
Sir.
who then how you propose for issuing the detention order, because detention order has to be issued against a particular person, so you have to show that this particular person is involved in series of acts, one after another, and every time he is getting bail, because he has the lawyers and he is getting the order, detention order quashed from the court. But sorry, he is getting bail. So therefore, it is a case where he should be detained. But you have to first identify the person.
Right.
So otherwise, if you don't, suppose one X is involved in one offense, he may be in offense in 3 offenses. Y is 2 offenses. But this time, after that was happened in the last year September. Now in January, taking reference to that thing, and again you said that similar offense has been committed without any material before you, that he is the person who is involved, then how you can sustain the detention order?
Lordship, we maintain the database. Means during the course of interrogation, when we arrest somebody, immediately he doesn't reveal anything
Yes,
much.
you have a material before you.
So
Why you are not referring this? That you have already recorded, you have arrested some persons, and their statement was recorded.
Yes.
Right? In the statement, they implicate those persons.
Yes,
That
yes,
with us, he is also involved.
Yes, Lordship, that is the thing that when we prepared a dossier also.
Yes, dossier also, yes.
We all take out all the past involvement, all the FIR numbers
So
involvement.
I think so far as now what you have said, you are following the correct thing. But you have to think over it that there must be an proximate corrections. That the offense committed or last offense committed, and when you are proposing for issuance of detention order. If you do that,
Lordship. Yes, Lordship. Most of the cases that we have put up so far for NSA, most of them have been successful to that extent because we have prepared the...
No. But lastly, whether you tell me whether it is succeeded in the court of law or not. But detenting order would be issued by the DM. No
Yes,
issue
yes.
to that.
Yes.
But finally, the matter will be taken up before the court of law,
Yes,
whether
sir.
court find the defects or not.
Court has not made any this thing against no such detention order has been struck in the recent past in my
No,
case.
I understand many orders have been set aside. So you to be very careful.
Yes.
But the process you are following, I find it is correct. What you said, that a person was involved in series of offense, maybe from the year of 25, and he was arrested and released on bail. Recently, another incident was happened, and in that case you have arrested 2 persons. Both of them implicated that he was very much involved, and after committing the offense, he has crossed the boundary and went to other state. So it is a case where you can consult the case to the detaining authority for issuance of the detention order. And you shall also be careful, after the detention order was issued, as I am repeatedly saying, that you immediately after the detaining the person within the stipulated period, that the grounds of detention accompanied by the documents relied upon by the detaining authority, which you have placed before it is you have to collected the materials and you have to take care of that. All materials have been shared with the detaining authority. So all those documents, the legible and legible copy of the document, and if there is any language variation, suppose I am speaking Bengali, so my statement was recorded in Bengal, you are speaking Hindi, but you don't understand Bengal or read or understand, then in this case it is the duty to translate my statement which is in Bengali in Hindi. Otherwise, then you will be certainly will be able to succeed. There will be no problem. And you will see that there is no loss of time, that it is to be done at the earliest opportunity, the ground of arrest. And it is the duty of the detaining authority to dispose of the application. And another thing you mind, that you have, suppose a person who has issued the detention order, he cannot take he has to take the decision. You in the statutes you will find who are the person, central government. This is possibly under UAPA, there have been specified who are the authorities before whom the representation has to be made, like National Security Act or NDPS Act. That in NDPS Act, Under Secretary and the Assistant Secretary are issued the detention order. So you have to make the order to the central government and the advisory board, and you have to insist the state government, whether I don't know whether there is an advisory board in the state of Manipur that must be comprised of the retired High Court judges, or the sitting judges also be. That should be the advisory board. You take care of this, I am sure that you will be able to succeed. And to protect the nation and the interest of the citizen of the nation, interest of the state. Thank you very much.
Thank you, Lord.
Thank you. Anybody else? Do you have any question? So let me finish now. Okay. Thank you very much.
Thank you very much, Lordship, for your thought-provoking and insights on this subject. Procedures and safeguards under Preventive Detention Law, including NSA, Prevention of Illicit Traffic in NDPS. And thank you once again, Lordship. Now we have the tea break for 15 minutes. Thank you once again. Good afternoon, everyone. So kindly please remain seated, all the participants. So now we can continue the closing ceremony. So it's my privilege to welcome our distinguished dignitaries to the dais. May I now request Honorable Respected Sir Sri Konthojam Govindas Singh, Honorable Minister, Home, Youth Affairs and Sports, Government of Manipur, to kindly take a seat on the dais. Thank you, sir. Thank you, sir. Now I request respected Sir Learned Advocate General Manipur, respected Sir Sri Lenin Singh Hizam, to kindly grace the dais. Thank you, sir. Finally, we are honored to have with us today, and I humbly request respected Sir Sri N. Ashok Kumar, Commissioner Home Government of Manipur, to kindly grace the dais and take the seat. Thank you, sir. Now we move to the felicitation of today's ceremony. It's a moment to honor and express our profound gratitude to the dignitaries whose presence has added immense value and dignity to this program. So we are deeply honored by the august presence of our special guest. Now I request Honorable Sri Konthojam Govindas, Ministers, Home and Youth Affairs and Sports, Government of Manipur, to be felicitated, and Honorable Ministers, and your visionary leadership and the guidance is governance and continue to inspire us all. For these felicitations, I request respected Sir N. Ashok Kumar, Commissioner Home Government of Manipur, to do the honors. So now I request respected Sir Sri Mukesh IPS DGP, so to be felicitated I would like to call the respected Sir Sri N. Ashok Kumar, Commissioner Home, Government of Manipur. Okay. On behalf of this, I would like to request IGP Sir Ningshen. Thank you, sir. Thank you, sir. To felicitate the respected Sir N. Ashok Kumar, so I would like to request respected Sir Ojes Mutum, Registrar General, High Court of Manipur, to do the honors. Thank you, sir. So I request respected Sir Ojes Mutum to remain here. So, we want to felicitate you also. Thank you, sir. To felicitate the Registrar Generals, sir, I would like to request Honorable Minister, Home Minister, respected Sir Sri Konthojam Govindas Singh, Honorable Minister, Home and Youth Affairs, Sports and Government of Manipur, to do the honors. Thank you, sir. Now we move to the presentation and distribution of certificate of appreciation. So for the certificate of appreciation, so I would like to first call upon respected Sir N. Kirtichand, Secretary Judicial, to kindly come on the stage. If Sai is not here, so anyone from the departments? No, sir. Okay, thank you, sir. Okay, yes, ma'am. Please kind. So I request respected Ma'am Patience Pami to receive the certificate of appreciation. And this will be felicitated by respected Honorable Home Minister, sir. Next, I would like to request respected Sir M. Manoj Kumar Singh, Joint Director, Manipur Judicial Academy, for this felicitation. So I would like to request the Honorable Home Ministers to do the honors. Thank you, sir. Now I would like to request Dr. Mayangbam Bito Singh, Joint Secretary, Home, to come on the stage and to receive the certificate of appreciation. This will be felicitated by respected learned Advocate General Lenin Singh. Okay, sir. Thank you, sir. Now I would like to request respected Sir Sheikh Asif Shah, Deputy Registrar Judicial, High Court of Manipur, to receive the certificate of appreciation from respected Sir AG. Thank you so much, sir, and thank you, everyone. Now we come to the part of the welcome address. So to give the welcome address, I humbly request respected Sir Sri N. Ashok Kumar, Commissioner, Home Government of Manipur, to deliver the gatherings.
Good afternoon to all. Respected Sri Kontojam Govindas Singh, Honorable Minister, Home, Youth Affairs and Sports, Government of Manipur, Learned Advocate General, respected Sri Lenin Singh Hijam, Honorable Justice Asim Kumar Rai, former Judge, Calcutta High Court, Registrar General, Manipur High Court, IGP, Temting, Vincent, DIGs, Deputy Commissioners, Joint Director, Manipur Judicial Academy, my dear colleagues, participants, friends from media, I am honored to be present the welcome address on this valedictory function of 2-day seminar on criminal justice administration, sir. This has started yesterday with the opening ceremony in the august presence of our Honorable Governor, Honorable Chief Minister, Honorable Chief Justice of High Court of Manipur and judges of Honorable High Court of Manipur yesterday, sir. And I take this opportunity to welcome our Honorable Home Minister for this valedictory function, sir. This program has been thought over for quite long time, sir. Honorable Sir also aware of the things in various meetings and other review occasions. We keep on discussing about on the effective implementation or producing the evidences and other documents before the courts, Honorable High Court, to get the justice done to the people and maintaining law and order, sir. In this regard, we have devised 4 module sessions, sir, which has started on Saturday, sir. And with the session 1, with the focus on charge sheet and investigation, covering the statutory timelines, evidentiary standards, and protocols for specified timelines, sir. The main focus for this is all the 4 pillars of which are required for implementation of this criminal justice administration has been involved, sir. Police, district administration, sir, prosecution, jail and correction department, sir, prison and correction department, prosecution, and Manipur Judicial Academy also, sir. They are all participated, sir. mainly from police side, sir, not only from Manipur police, sir, we have invited the NIA, CBI, CRPF, as well as Assam Rifle also participated, sir. Mainly our border states, many cases related to NDPS also involved, so that these are the things very important, sir. As such, the module 1 was focused on charge sheet and investigation, and the module 2 focused on trial in criminal cases, sir, addressing the appreciation of evidence, examination of witness, and strategies to prevent prolonged trials, sir. These 2 sessions have been held yesterday, sir. Then in these 2 sessions, sir, resource persons are coming all over India. They are legal luminaries, sir. Sri Siddharth Ludra, Senior Advocate, Supreme Court, and former Additional Solicitor General of India also present, sir. And Honorable Miss Justice Sonia Gokani, Madam, also was present. She is former Chief Justice, Gujarat High Court, as well as Honorable Mr. Justice R. Basant, Senior Advocate, Supreme Court, and former Judge, Kerala High Court, also present, sir, yesterday. And sir was yesterday also there, sir. Honorable Mr. Justice Asim Kumar Rai, sir, and done the honor, sir, for yesterday's session. Today's session on to Module 3 and Module 4 held, sir, starting from today morning 10 o'clock, sir. The third session is mainly focused on arrest and bail, focusing on statutory procedures, constitutional mandates, and guidelines safeguarding the personal liberty, sir. Balancing the personal liberty as well as doing the duty. This was a very important session, especially for police as well as the district administration, sir. And in this case, sir, resource person Sri E.V. Chandrasekharan, Special Public Prosecutor for NIA, Madras High Court, was present, sir. Miss Sonia Mathur, Senior Advocate, Supreme Court, joined virtually, sir. They have also done the honor, sir. And Module 4 focusing on preventive detention law, including NSA, prevention of illicit traffic, PIT in NDPS, sir. This is very, very important focused area for our states. And this session covered by Honorable Justice M. Nirmal Kumar, sir, Judge, Madras High Court, and as well as Honorable Mr. Justice A.K. Rai, sir, who is present now, sir. And this was very interactive, sir. The Superintendent of Police from our district as well as district administration deputy commissioners were also present, sir. Sir, this 2-day seminar on this focusing on the criminal justice administration based on the new laws which are common, BNS, BNSS, BSA. This is very, very important for all of us and especially for our states, sir. And once again, I take this opportunity to welcome Honorable Home Minister, sir, and other dignitaries present here for this closing function. And nevertheless, sir, I want to mention here the participation from the police, especially, sir. They all, last 2 days, they present, sir. We want to take forward this in more focused way, maybe through VC with the resource persons, with the help of learned Advocate General as well as Manipur Judicial Academy, maybe in a 2 months gap for group of master trainers, sir, or trainers of trainers, so that they can understand and they can go forward and teach the same thing at the local level, sir. With this, I once again welcome all of you for this closing function. My sincere appreciation and thanks to Manipur Judicial Academy as well as High Court of Manipur in making this event a grand success by bringing all the resource person. Nevertheless, I should mention the name of our learned Advocate General. Without his brainchild and follow-up, sir, this will not be this success, sir. Thank you very much, sir.
Thank you very much, sir. So before we come to the valedictory address, so now we take a moment to distribute the certificate of appreciations. Now I may request respected Ma'am Passes Mamai, Joint Secretary, Law and Legislative Affairs, to receive the certificate of appreciation. And this will be felicitated by respected Sir A.G. Thank you, sir. Now, I would like to call upon again respected Sir T.A. Santi Kumar Singh, System Analyst, High Court of Manipur, to receive the certificate of appreciations. So, among the system analysts or system officers, so kindly come on the stage and receive the certificate of appreciation on behalf of T.A. Santi Kumar Singh. And this will be felicitated by respected Sir Lenin Singh Hizam, Advocate General of Manipur. Thank you, sir. Now we come to the valedictory address. So to give the valedictory address, I humbly request Honorable Respected Sir Sri Konthozum Govinda Singh, Honorable Minister, Home and Youth Affairs and Sports Government of Manipur, to deliver the gathering.
Good evening. On the dais we have respected learned Advocate General, Commissioner, respected Commissioner, Home Department, Government of Manipur. Of the dais we have Lord Chief Justice Roy, respected officers of Manipur Judiciary Academy, judicial officers, respected prosecutors, representative from Central Paramilitary Forces, district magistrates, superintendent of police from different districts, members of Bar Association, participants, media persons, ladies and gentlemen. So I think I should not take much of your time because you might have already sitting here for quite a long time since early morning. And this continuous rain also helps us to keep you inside this hall. So it's better not to take much time. So it's my privilege to join the valedictory session of this 2-day seminar on criminal justice administration. I also congratulate to the Law and Legislative Affairs Department, Home Department, and the Manipur Judicial Academy for organizing this timely and important seminar. May I also appreciate the distinguished resource persons and the participants for their valuable contributions over the past 2 days. In the prevailing situation of our state, this seminar has provided timely and valuable insights to strengthen our criminal justice system in our state as well as the country. The expertise here by the resource persons has strengthened our collective resolve to restore normalcy and build a peaceful, progressive, developing and prosperous Manipur. An effective criminal justice system is foundation of a democratic society. It safeguards the rule of law, protects citizens' rights, ensures accountability, and strengthens public confidence in governance. Capacity building program like this seminar help equip stakeholders to meet evolving legal and institutional challenges. The Bharatiya Naya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Abhinayam marks a significant reform in India's criminal justice system. These laws aim to deliver faster and more efficient justice and also promote victim-centric justice, encourage scientific investigation and digital processes. and also enhance transparency and accountability. This seminar has covered important aspects such as investigation and prosecution, trial procedure, evidently standard, arrest and bail, constitutional safeguards, and the swift justice deliberation. Just now, I also learned a little bit of our Lordship Justice Roy when he differentiated between the punitive arrest and preventive arrest. So little bit I learned when I listened to him in these few minutes. So most of the participants here might have already interacted and come to know a lot of things which we could never be imagined. Effective implementation requires seamless coordination among judiciary, police, prosecutions, prison administration, forensic experts, and legal services institutions. The government of India has introduced the new criminal laws to modernize the justice delivery system. The government of Manipur is committed to continuous training and capacity building, modernization of police infrastructures, greater use of digital technologies, strengthening forensic capabilities, involving coordination among all criminal justice institutions. These efforts aim to ensure justice that is efficient, transparent, and fully consistent with constitutional values. For our Manipur, a strong criminal justice system is essential to sustaining peace, stability, and inclusive development. A professional, fair, and accountable justice delivery system strengthens public trust and supports long-term social harmony. Every stakeholder has a shared responsibility in ensuring effective implementation of these reforms. India's criminal justice reforms reflect the country's commitment to a modern, citizen-centric, and technology-enabled legal system. Their success depends not only on legislation, but also on the dedication, integrity, and the professionalism of those entrusted with implementing them. Continuous learning and institutional collaboration will be key to achieving these objectives. Let the knowledge gained during this seminar translate into improved professional practices. It also should continue updating our knowledge as the new laws evolve through judicial interpretation and the practical experiences. Let us work together with commitment, integrity, and a shared sense of public service to strengthen justice delivery. We should all remember that every fair and timely decision enhances public confidence in the rule of law. Last but not the least, I congratulate all the participants for their active engagement and spending their time in these 2 days seminar. A strong criminal justice system is not measured only by law it enacts, but by fairness, integrity, and commitment with which those laws are implemented. Let us work together to build a justice system that is efficient, transparent, human, and worthy of the trust of our people. I hereby declare this 2-day seminar, Criminal Justice Administration, is successfully concluded. Thank you. Jai Hind, Jai Manipur.
Thank you very much, sir, for your inspiring words, and thank you once again, sir. To address the Board of Things, I humbly request respected Sir Shri M. Manoj Kumar Singh, Joint Director, Manipur Judicial Academy, to deliver the gatherings.
Good evening, everybody. Mayam punamupu khairamjari. Respected Chief Guest, His Excellency, Honorable Governor of Manipur, Shri Ajit Kumar Bala, Honorable Chief Minister of Manipur, Shri Yumnam Khemchan Singh, who presided over the function, Shri K. Govindas Singh, Honorable Minister of Home and Youth Affairs, Honorable Mr. Justice M. Sundar Singh, Chief Justice of High Court of Manipur, our special guest, the guest of honor, Honorable Mr. Justice Sri Anthem Bimol Singh, Honorable Mr. Justice Aribang Guneswar Sharma, Shri Lenin Hijam, respected learned advocate, distinguished officers of the government of Manipur, honored resource persons, learned senior advocates, Ozes Mutum, Registrar General of High Court of Manipur, learned judicial officers, learned advocates of the High Court and the District Courts, learned prosecutors, police officers, officers of Central Paramilitary, law students, all the respected invitees and the ladies and gentlemen. It is my great privilege to have been asked to propose a vote of thanks on this remarkable, humble occasion. It is an evident fact that conviction rate in India is very low, even in our state. I agree that there may be some various reasons. However, sensing this alarming situation, the learned Advocate General thus felt that it is the right time for sensitization all the stakeholders involving in the administration of criminal justice, and accordingly has initiated for organizing these two-day seminar. And our Honorable Chief Justice was pleased to approve the proposal of the learned advocate and directed us to organize this seminar. Further, it is admitted fact that an event like this cannot be happen overnight. The wheels start rolling weeks ago. It requires planning and a bird eyes for details. We have been fortunate enough to have our Lordship Honorable Chief Justice and his companion justice along with learned AG, and under their leadership and guidance has made this seminar a grand success. I also express our deep sense of appreciation and thanks to the Honorable Governor of Manipur, Honorable Chief Minister of Manipur, and the Honorable Chief Justice of the High Court of Manipur for their presence amongst us in spite of heavy schedules and their valuable thought-provoking speeches in the inaugural function, which inspire all of us for rendering our respective duties for upholding and strengthening the criminal justice administration without fear and favor. I, on behalf of the organizer, express our humble gratitude and thanks Shri Siddharth Rutra, Senior Advocate, Supreme Court of India, Honorable Mrs. Justice Sonia Gokani, former Judge of Gujarat High Court, Honorable Mrs. Justice R. Bashan, former Judge of Kerala High Court, and Honorable Mrs. Justice Asim Kumar Roy, former Justice of Calcutta High Court, Shri Y.B. Chandru, Special Public Prosecutor for NIA, Madras High Court, and Mrs. Sonia Mathur, Senior Advocate, Supreme Court of India, and Honorable Mr. M. Niril Kumar, Judge of the Madras High Court, for exposing your vast experience and enlightening us to the topics suggested by the organizers, which are very much essential in strengthening the administration of criminal justice. Sir, Madam, we hope for your further cooperation and communicating with us in the future for further cultivating us. Thank you, Sir, Madam. I also extend my heartfelt gratitude to the C.N. Ashok Kumar, Commissioner Home, Government of Manipur, for giving welcome address in this closing ceremony. I also extend my heartfelt gratitude to Shri Konthongcham Govindas Singh, Honorable Minister of Home, Youth Affairs and Sport, for his presence among us in spite of heavy schedule and his valuable thought-provoking valedictory speech in this closing ceremony. Thank you, sir. I also extend my heartfelt congratulations to the members of the Bar Council of Manipur, senior advocates, learned members of the High Court, and all members of Manipur Bar Association, learned judicial officers of the High Court Registry, officers of the Home Department, officers of Law and Legislative Affairs, public prosecutors of the High Court and District Courts, police officers, forensic experts, officers from paramilitary and the Central Forces, Legal and Defense Council, remand lovers, resources, volunteers of the High Court Bar Association, law students, and members of the High Court Legal Service Committee, and all others whose presence dignify this gathering, and we extend our warm appreciation in your active participation in this seminar. I also would like to take this opportunity to place our own record our heartfelt thanks to all the officers and the learned junior advocates of learned AG, officers of Home Department, officers of Law Department, officers of Information Technology Department, and officers of Manipur Judicial Academy, who run here and there for the last 1 week to make grand success of this seminar. Last but not the least, I would also like to show my humble appreciation and thanks to the Directorate of Information and Public Relations, Government Manipur, for raising an anchor along with the electronic and the print media friends. And also thanks to the electronic and the print media friends to your selfless service in covering today's seminar, because through your medium, only our message of this seminar can be reached to the people of this state. Lastly, I, on behalf of the organizer, express many thanks to the band party of the first MR, for playing their instruments to the beautiful national anthem of this country on the opening ceremony. I also thank all the persons who involved in providing delicious meal and snack to us for these 2 days. We, the organizer, hope that all the participants will definitely gain some knowledge from the wide deliberations of the resource persons who are eminent legal luminaries of this country. We, the organizer, will acknowledge this, acknowledge that this 2-day seminar is concluded in grand success if all the participants have gained some knowledge from this seminar. Thank you, Thagachari. Jai Hind.
Thank you, sir, for your eloquent vote of thanks. With this, we come to the formal conclusion of 2 days seminar on criminal justice administration, organized by Home Department and Law and Legislative Affairs Department in collaboration with Manipur Judicial Academy. On behalf of the organizers, I extend our heartfelt gratitude to the honorable dignitaries, esteemed resource persons, and respected judicial officers, distinguished participants, and every individual whose presence and contribution have made this program an outstanding success. May the knowledge and insights gained during these sessions continue to guide us in strengthening the administration of justice and upholding the rule of law. Thank you once again for your kind, gracious presence here and making this function a wonderful one. Thank you once again. So, I request all the participants, we have a tea program, so just after this session, so just have the tea and we formally close the session.